Hello guys, this is Kachalia and yes, I am not live available right now, but I am not too far away. Yes, just a message away. I am right here with you and today our target is revising maximum portion of our CA final law syllabus. Now guys, as you can see on the screen above, the ABC analysis for our CA final law upcoming exams has been shared with you. Understood? So this ABC is my personal analysis. Yes, according to the past exam trends, we have come up with this ABC analysis. All right. And mind you, this is a very latest video being recorded and it is for May 23 exams. First up revision coming up on your screen as you follow. Director's chapter, that was the target, considering the most important sections of this chapter on priority, along with many other chapters from other laws portion also. Let me tell you, the problem with the people that in during the exams they face specifically is, sir, we focus majority on company law and other laws we simply take an overview. Yes or no? Company law, the moment we start studying the law paper, we will start with the director's portion. We will start with the director's portion, and it itself is so big. 53 sections is not a joke. It itself is so big that by the time we finish our director's portion, we are already like, sir, already tired. And then what do? We go to the other laws and we start with FEMA, which is equivalent or more bigger than the director's portion. And then we feel like, woof, we are done for the day, right? And that is where we make a mistake. Plan and study. Study according to the weightage and study smart. All right. Not wasting more time in all these discussions because we have a lot of things to cover today. So let's start with the director's portion up front coming here. Guys, when we talk about the director's chapter, as you should be aware, it starts from section 149 and goes up to section 205. All right. And having 149 to 205, there are two sections, 194 and 95, which have been omitted. All other sections are there. These sections are further bifurcated as 149 to 172, 173 to 193, 196 to 205. Understood? This is how the bifurcation is there. So this is how your director's portion has been divided. Number one. Sir, in this particular portion, when we see what are the important sections. Okay, so here I am making a list of important sections per chapter. In the first particular chapter, as you can see, 149 to 172, which talks about appointment of the board of directors, your section 149 itself will be important. Your 152 will be very important. These are very big also and very important, of course. In the second lot, if I have to select the very important sections, I will go to first 184 with 188 and 189 because it is a trio of sections. These three sections have to be done together. Okay, so this is a 84, 88, 89. Along with them, 186, of course, is very important. Then we go further under the third part. We have 197 being the most important. Of course, no negotiations over there. I'm sure nobody will argue on that too. And apart from that, if I have to select a combo, we'll go with 196 and 201. Okay, because both the sections work again together. So this is how we select the most important A category sections from the director's portion. Of course, all the sections, other sections are also relevant, but these are like the most important ones that we have to study, we have to go through. You can also add 185 to this list. 185 and 186. I am using 85, 86, both of them. My only reason is it causes a little bit of confusion because both the sections are talking about loans. 85 talks about loans to directors and 85 talks about loans, investments, etc. Understood? So that is why I'm adding 85 to this list. This is how these sections are. Having said that, you also have section 177 and 178, which are audit committee, nomination remuneration committee, stakeholders relationship committee related sections, and of course they are also reasonably important, but not adding them to the list because I'm pretty sure these sections you might also study when you do SEBI LODR. That is your LODR regulations. Understood? So that is also when you might study these, and that is why I'm not including them over here. Okay. So this is your important portions from the directors chapter. Why waste time? Let's start with the quick revision. Guys, as we talk about quick revision, first of all, we talk about section 149. What do you know about 149? 149, first chapter, when you start with the director's portion, right? So what does it say? 149 says, are you a company? Yes. Are you a company? Yes. Well, then if you are a company, you must have company to have board of directors. You must have board of directors, right? How? How do we talk about a company having board of directors? So in this particular section, first we will be talking about minimum number of directors. Second, we will be talking about maximum number of directors. Third, we will be talking about resident directors or a concept similar to resident directors. Next, we have to talk about women directors. Yes. Next, we have to talk about a concept of casual vacancy for women directors and independent directors. And then comes the father of everybody, that is independent directors. These are the most important portions, or I should say all the portions that you have to study under 149. Nothing more will come from 149. Nothing more is there in 140. Okay, so let's start one by one, decoding all of them. So sir, minimum, what do you have to say about minimum? I'll bring it up over here. Minimum, sir. Minimum. Let's bring it over here. First, minimum directors. Let's bifurcate it. Minimum 3, 2, 1. Sir, what 3 to 1? What do you mean by 3 to 1? Acha, acha. Okay. Let me bifurcate it further. Minimum directors in case of public companies. Minimum directors in case of private companies, and minimum directors in case of one-person company. Sir, public company, private company, one-person company, how many will be there? 3, 2, and 1. Sir, how about maximum directors? Maximum. Maximum, tell me which company are you talking about? Practically speaking, sir, it is immaterial. Whether it is public company, or private company, or one-person company, for all of them, maximum number of directors is always 15. Maximum is always 15. Understood? Not less than 15 directors. Is that clear? Maximum is 15. Oh, okay, sir. But, two questions I have. Question number 1, sir, OPC and 15, how it is possible? And question number 2, what if I want to have more than 15, 15 plus I want? What to do? Well, let's address both these questions over here. Sir, OPC and 15 directors, how is it possible? Let me ask you guys, why is it not possible? When I talk about one-person company means what? One-person company means the company belongs to one person. One-person company means company has one person who is the owner of the company. One-person company means one person is the owner, which means one person is the owner, meaning one person is the shareholder. Yes or no? That is a one-person company, meaning one shareholder is the owner. Is it necessary that every director of the company must hold the shares of the company too? No, not at all. Am I right? Not at all. In that case, why do you think that in case of a one-person company, more than one directors cannot be there? Right? There can definitely be more than one directors in case of a one-person company. And now let me go further. As we go further, in case of an OPC, sir, apart from OPC, public, private, total 15 directors. What if I want to have more than 15? Yeah, why not? Definitely you can have more than 15 also. Pass SR in GM. Yes or no? For 15 plus, all you have to do is pass SR in GM. What is SR in GM? A special resolution in the general meeting. Correct. On the top of it, let me tell you, if you are a government company, if you are a government company, then this maximum 15 directors can be there. This limit is not applicable for a government company. Matter of fact. Yes, the limit won't apply only to you. Understood? Sir, what else? Well, you saw minimum, you saw maximum. Let's talk about resident. Sir, resident means any person who has stayed in India for not less than 182 days in the previous financial. We have studied this in Income Tax Act. Am I right? Of course you are right. Of course you are right. But this is Companies Act, not Income Tax Act. So here what the provision says, here the provision says during the current year. During the current year, any company, whatever type of a company you are, you should have at least one director, at least one who has stayed for how much? Same, not less than 182 days, not less than 182 days. Understood? During the current year should be there in India. Simple provision. Yes, sir. Apart from that, what? Apart from that, the provision over here says what, Sir, let us say, today is what? Today is 9th of April. You are watching this video. Am I right? So today, let us say it is 9th of April and today I have incorporated a company. Correct. In that case, sir, considering 9th of April, meaning 9 days of April, 8 days of April are already gone. In a year, total 365 days are there, and you are saying 182 days a person should be there in India, current year. But in this year, if my company gets incorporated today on 9th of April, then sir, first 8 days of April are gone. Meaning in this year, totally how many days are left? 357 days are only left. Yes or no? So for 357 days being left, also 182 days criteria will be there? Of course not. We will do cross multiplication and proportionately bring down the number of 182 days. Let me take an easier example. Let us say today is 1st of January when my company got incorporated. Yes or no? So in this particular year, how many days are left? Total 365 days are there. Then we want 182 days a person to stay in India. But this year, it is 1st of January when my company got incorporated. So approximately I'll say 91 days are left in this year. Right? So in 91 days left, how can I say I need a person who stays for 182 days in India? Not possible, no? Cross multiply, proportionate number you will get. That many number of days a person should be there in India in this particular year. Understood? He will be considered as what? Resident director. At least one person should be there like that. Clear? Then we go to woman director. Sir, what is a woman director? Woman director. Provision says minimum one woman director should be there. Minimum one woman director should be there. So then my question is, sir, minimum one woman director should be there, but where? Where? Which type of companies are we talking about? And let's divide for woman director also. What type of companies do we know? Sir, we know public companies and we know private companies and we know one-person companies. Perfect. Sir, public companies also we can have a further bifurcation as listed public companies and unlisted ones. Yes or no? So here they are saying minimum one is always required. Here they are saying terms and conditions apply. Here they are saying you decide if you want, you appoint. If you don't want, you don't appoint. Not compulsory, applicable. So we are writing not applicable. The terms and conditions are saying that, sir, if paid up share capital or turnover, we'll compare these limits. There is an or in between. Paid up share capital greater than equal to turnover greater than equal to say 100 crores or 300 crores, then woman director is required. Understood? Sir, how many? That will be same, my dear friends. Minimum one, not more than one. Understood? Not more than one being compulsory. You want to appoint more on your own wish, you appoint 10. Appoint all directors as women directors. We don't have any problem, any objection, no issues at all. But minimum one should be there. Is that easy enough? Yes or no? This is a revision class. Don't forget. And that is why we are going a little bit faster. But don't worry. I'll give you ample of time to read and understand the provisions too. Okay. Now, let's go further. There is one more provision of casual vacancy. Sir, what do you mean by casual vacancy? First of all, remember, this provision is applicable only for women directors and independent directors under section 149. Okay. Under 149, it is only for women and independent. Sir, what if any other director is there who died? Yes or no? Who died or who resigned or who was removed? Possible, no? Yes or no? Sir, well, in that case, We will refer section 161 subsection 4. Okay. So here what the provision says, in case of casual vacancy, no, within 3 months or before next board meeting, whichever is later, whichever is, how can you say whichever is earlier? You tell me. Whichever is earlier, if you say within 3 months or before next board meeting, whichever is earlier, meaning right now, if I'm recording this class and if you understand, this is, I have a board meeting scheduled in 2 hours and I died. I died. So within 2 hours, my board of directors, you are saying before next board meeting or 3 months, whichever is earlier, if I die right now, with 2 hours board meeting is there. How will they will come for my funeral or they will appoint a new director over there? Possible? Not possible. So it is whichever is later. Understood? Clear? Easy? Right. Let's go to your most important concept of independent directors now. Okay. But before I go to independent directors, let me show this section of 149 to you on the screen, which you can just refer through once. Okay. I hope you are all having some or the other notes available with you. If you are not having the notes available with you, I'll give you the notes. Okay. These notes are available on www.edujahan.com. Okay. You can go to the site and under the free downloads section, you will get these notes available. So you can take it from there. All right. Here you go. Take the notes and revise super fast. I'll highlight the important points and words for you. Okay. So make sure if you are making your summary notes with me, whatever I am highlighting, that should be there over there with you. Okay. Current financial year. Okay. Newly incorporated company means what? Just now. Say on 1st January, company got incorporated. So for them, it will be 182 days? No. It will apply proportionately. Private and OPC, we already said not applicable. Here, minimum one. Again, minimum one. Conditions, as you can see. Always remember, paid up share capital, always greater than equal to. Turnover also, always greater than equal to. Alright. Then you have your concept of casual vacancy. Acha, those who do not know, paid up share capital turnover, all the figures will be as per the latest audited financial statements only. Casual vacancy, we have already discussed for woman and independent director, 3 months or next board meeting, whichever is later. You have to fill the casual vacancy within that time. We talk about independent directors. What do we know about independent directors, sir? Independent director, basic requirement before I explain which company should appoint. Let's have a little bit of chat about who is an independent director or who can be appointed as an independent director. Before I go over there, just make sure you have all these points noted with you. Okay. Have all these points noted with you and we will go to independent director in 1 minute. Understood? 1 minute. Get through these points fast. Are we done? Shall we proceed? Okay. All right. Independent directors. So we were asking ourselves a question, sir, who can become an independent director or what is an independent director? Let us understand the concept first. Independent director. So see guys, independent director, as the name itself says, independent, meaning this person should not be connected to your company in any ways. He should not be an employee of your company. He should not be a significant shareholder of your company. He should not be a promoter or director of your company. Meaning, there should not be any relationship between the company and this person, any relationship between both of you, which might affect his decision making. His decisions have to be independent, just like our chartered accountant auditors are there. Yes or no? Our company secretaries who get appointed as secretarial auditors also. The decisions have to be independent. Understood? Unbiased or impartial decisions have to be there. So, first of all, let's answer questions one by one. Which companies are required to appoint independent directors? So we bifurcate it as listed companies always required to appoint independent directors, which is a requirement of 149(4) also, which says that minimum one-third of the total directors will be appointed as independent directors. Number one. Then we talk about unlisted companies also. Unlisted companies, they have said minimum two independent directors are required. Here one-third they said, right? One-third of the total directors. Here they are saying minimum two should be there. But conditions, there are three. Pay attention to the conditions if you don't already know it. Paid up share capital or turnover or outstanding liability. Any one condition also satisfied, you have to appoint independent directors. Sir, sign which sign? Always greater than equal to. Always greater than equal to. And this will be always greater than. Okay. Always greater than equal to, and greater than. 10 crore, 100 crore, 50 crore is the limit. Sir, going further, private companies, the condition will not apply. Is that clear? Now, what is this red color point? So here what they are saying, first point here they are saying, if you read the first point, they are saying that, see, once my turnover had crossed 100 crores, so we appointed independent directors. Okay. After that, my turnover never crossed any limit. I'm an unlisted public company. My turnover has never crossed any limit thereafter. But even if my turnover has never crossed any limit thereafter, should I appoint an independent director all the time? Or that independent director who I appointed, shall we have him in the company all the time, at all times? Is it compulsory, sir? Is it necessary? No. Not at all. So then what? That's what I'm telling you. So then what you have to do is, in such cases, no, if you do not satisfy paid up share capital or turnover or outstanding any of the limits for a consecutive period of 3 years, you don't satisfy any conditions, then from the next year, no need to appoint any independent directors. Is that clear? So here the point is given, if the company fails to satisfy any of the conditions, any one also satisfied, then you have to appoint independent directors. But otherwise, continuous period of 3 years, then this rule will stop. It will cease to apply. Is that clear? What is the second point? Second point says, the following type of unlisted public companies have been exempted. Who are they? Joint venture, wholly owned subsidiary, and a dormant company, which is defined under 455 of the Companies Act. They have been exempted. No need for independent directors. Okay. Then there is a question, who can become an independent director? Okay, before I address this question, let's address a few other small provisions which are there, so that we can quickly revise them first. Once I have appointed an independent director, will I have him in the company forever? Of course not. So what is the term of independent director? Term, very simple, sir. Appointment will be done for one term only. Definition of one term given over here is what? Maximum 5 years. Maximum 5 years. And this one term appointment which you are doing, you can do it by passing an ordinary resolution. And thereafter, you can talk about reappointment, which can also be done for one term only, which will also be maximum 5 years. But this time, it is reappointment. It will be done by special resolution and a separate disclosure in the board of directors report as to why are we reappointing such person. Also, the person, the independent director, has to give his free consent that is willing to be reappointed. Sir, two terms are over, one term of appointment, one term of reappointment. Thereafter what? Thereafter, not eligible for further reappointment. He is not eligible for retirement by rotation also. Sir, what is retirement by rotation? Guys, if you want to understand retirement by rotation, no, there is a section known as 152, under which we will talk about the sixth point, that is the subsection where we will talk about retirement by rotation. Okay, this entire concept I will cover over there, which says that those directors who do not have a fixed term, like independent directors have a fixed term, 5 years, right? But those directors who don't have a fixed term, what about them? So they are eligible to retire by rotation. How? That we will talk when we do 152. Okay. Until then, just remember, independent director not eligible for retirement by rotation, and he will not further be reappointed also. He will go for a cooling period of 3 years. Understood? So there will be a cooling period of 3 years which will be attracted. Next provision which you can see is very simple. Code of ID, meaning the code of conduct, rules, regulations. Which ones will he follow? It is given under Schedule 4 of Companies Act. That's all you have to remember. Then, sir, declaration is required from the independent director. What declaration do you want? Sir, just a declaration that he is independent. Just a declaration that he is independent. Okay. When do you want this declaration? Sir, very simple. In the first board meeting that he will participate, okay, and thereafter in every first board meeting, wherever there is a change in the circumstances which we feel might impact, or which we feel might have an effect on the status or say on his independence, we feel his status of independence may be affected. In that case, sir, we want him to give just a declaration that he meets all the criteria as given under 149.6. What is 149.6? That is what I have left above, which is a question: who can become an independent director? Conditions are given. To satisfy those conditions, you can be appointed as independent director. Otherwise, you cannot be appointed as independent director. Simple as that, right? Sir, should we give any remuneration to independent? Of course. Who works for free? You tell me. Who works for free? Yeah, this lecture that I am giving you today is for free. Absolutely. But otherwise, who works for free? You tell me. Right? So, independent director also will not work for free. Sir, what does the independent director need as a part of his remuneration? Or what will we give the independent director as a part of his remuneration? Let me tell you. Sir, as a part of his remuneration, independent director will be eligible for sitting fees. Yes. Independent director will be eligible for expense reimbursements. Yes. Independent director will be eligible for profit-based commissions. Yes, of course. Profit-based commission means what? His remuneration will be certain percentage of profits. Oh, sir. Okay. So when he will come and sit in the board meeting, he will get sitting fees. Company will invite him to attend the board meeting, so company will give him expense reimbursement also. And profit based commission, sir, can we profit based, can we elaborate? Of course, yes. Understand. Profit based commissions means what? When we revise section 197, you will come to know that remuneration of every director is certain percentage of profits. And in case there is no profits, then there is a schedule of effective capital which is given under Schedule 5, the table of effective capital. I will show you the table also. Okay. In case there is a loss, then also remuneration is something we have to give. So in case of loss, how we will give remuneration? For that purpose, we have the Schedule 5, that is the table of effective capital. Is that clear? All right. Sir, an independent director is not eligible for ESOP. He will not be eligible for employees stock option plans. Is that clear? Liability of independent director will be how much, sir? Liability, well, see, whenever we say all the directors of the company will be liable, liability of independent director, he shall be liable only and only to the extent of any actions, any acts of omission, or any acts which are committed with his knowledge, or with his negligence, or with his connivance. Connivance, you understand? Connivance, connivance. Fox is a very cunning animal. That connivance. Understood? So only then ID will be liable. Otherwise, ID will say, I don't be there in the company every day for 365 days. Why should I be held liable for anything? Right? So ID will not be liable. Section 8 companies have been given a special exemption over here, that any provision of independent directors, any provision, independent director provision starts from 149(4). So all these subsections are about independent directors only. Correct. Any provisions of independent director will never apply to a Section 8 company. They have been exempted over here. Is that clear? Yes or no? Let's quickly go through these points once. See if we have any questions, or take the markings if you have the notes very quickly. Okay. Are we done? Let's address the most important question over here. Who can become an independent director? All right. Sure. Let's address this question. I'll put it over here. Pay attention. Who can be appointed as independent director? To answer this question, I'm giving you a keyword. I am rough when. I am rough when, where I have two M. Okay. Alternatively, you can change the keyword also. I am rough when, you can make it I am for when also. Okay. I am for nev also. Whatever you want, doesn't matter. These are points only. Starting with the first one. I for integrity. What do you mean by integrity? Integrity means integrity. Sir, are you a person of integrity? Yes. Will anybody say I am not a person of integrity? No, sir. Nobody will say. Exactly my point. Nobody will say that, right? So, are you a person of integrity? Yes, I am a person of integrity. But nobody will say you are not a person of integrity. Nobody will agree. So, what the provision says, every person who wants to be an independent director should be a person of integrity. But how will you prove it, sir? How will we prove it? Well, to prove it, what the law says over here, to prove it, you don't have to do anything. Just go for interview in the company, and the board of directors of the company will determine whether you are a man of integrity or no. If they feel you are, you are. If they don't feel you are, never mind. Go to some another company. Understood? Remember, if you are a government company, then not the board, but the respective department or ministry of the government will determine. Is that clear? Then let's go to the next point. I M1. M1, monitor. You want to be appointed as independent director, you should not have any monetary transactions with the company. Sir, how is it possible? For example, I want to be appointed as independent director in Reliance, but I am using a SIM card of Reliance. My car is using the fuel of Reliance. My home milk comes from Reliance Jio Mart. Sir, these 2 months I am watching IPL also on Jio Cinema. How is it possible? They said, no, not like that, not like that, not like that. When we say monetary, it means any transactions which you are entering into, which are in ordinary course of business, which are done at arm's length price, okay, which are done in the ordinary course of business, which are done at the arm's length price, those transactions are all okay, no problem, allowed. Is that clear? Okay, no problem, allowed. But apart from that, you should not enter into any other monetary transactions which might affect your independence. Understood? Huh. Taking remuneration from that company, that is of course allowed. You cannot say it is a monetary transaction. So that is okay. That is allowed. Sir, we talk about M2. M2 talks about what? M2 talks about, again, monetary transactions, but monetary transactions with your relatives. Now we need to understand this point very clearly, because this is the point which creates a mess in the minds of the students. Okay, so let's understand monetary transactions with the relatives. Here what the provision says, if I want to be appointed as an independent director in any company, my brother goes and takes 2 shares of that company. He goes and takes 2 shares of that company. He gives money to buy the shares. So he has done monetary transaction. Yes or no? Monetary transaction. So I am disqualified. My brother is not a share trader. Okay, he has some other business of his own. So it is not even in the ordinary course of his business to buy the shares. Am I right? Now I am always disqualified. I am always disqualified. But does that make any sense to you? Does it? No. So how do we interpret this provision? How do we interpret this provision? Let's understand what the provision says. See, I will first take down the limits for you. First condition is 50 lakhs or 2% of paid up share capital, whichever is less. Second, indebtedness not more than 50 lakhs. Third, given guarantee or security not more than 50 lakhs. And fourth, any other monetary transaction value how much? 2% or more of the gross turnover. Okay, fine. Let's take them down. See what are the limits given over here. First condition, your transaction value should be how much? 50 lakhs or 2%, whichever, of paid up share capital, whichever is less. My relative who bought the shares, the transaction value was 45 lakhs. Okay, so it is 2% or a paid up share capital is 100 crore, 1000 crore, more than that only. So 45 lakhs, whichever is less. Am I contradicting the limit? No, I'm not crossing the limits. Okay. Second, indebtedness should be not more than 50 lakhs minus 40. My relative's indebtedness 45 lakhs only. Guarantee or security provided not more than 50 lakhs should be there, 25 lakhs only. Okay, so not contravening the limit. Any other transaction should be not more than 2% of the gross turnover. Say for example, gross turnover is 1 crore. 1 crore. So 2% will be 2 crores. No, 1 crore. So 2 lakhs. Am I right? Here it is 40 lakhs. Wait, then I'm crossing the limit. Let me increase the gross turnover to 100 crores. So 2% will be 2 crores. Am I right? 2 crores. Transaction value 40 lakhs. Within the limit only now. No problem. Okay, sir. Sorted. Am I contravening the limits? Sir, here no. Here no. Here no. Here no. But sir, you are forgetting one important thing. What? Sir, in the fourth point, if you read what they had told, they said your transaction value should be not more than 2% of the gross revenue or gross turnover. Yes or no? Sir, when we say transaction value, sir, this is also a transaction, this is also a transaction, this is also a transaction. Yes or no? These are also some type of transactions only. So in these cases, sir, if I add all of them together, my total is 1.45 crores. Yes or no? 1.45 crores. 2% of the gross turnover, 100 crores. 100 crores, 2% will be 2 crores. Not contravening. I am eligible to be appointed as independent directors because total of all of them is not more than 2%. Understood? So I am eligible. Sir, say for example, what if this was 10 crores? Well, then your entire dynamics will change. Then my 1.45 crores will be more than the 2% of the gross turnover. Am I right? It will go to around 20 lakhs, I feel. 20 lakhs and 1.45 crores. Compare, my transaction value is more than 2%. I am not eligible. Sir, how can we determine this? What you are saying? See, read what they have given. What they have given in the last point, whether singly, meaning single transaction, any other transaction singly, or in combination with 1, 2, and 3, which we just saw. Combination of all. It should not be more than the given limit. And that is why we need to understand the limits properly over here. This is the example. That is the reason I gave you. Is that clear? Understood? Yes or no? If you have any questions, you can always put it up in the chat box. As quickly as possible, I will revert to your questions. Okay. Sir, next, this is important point. Now other points are simple. I am Rockpen. You should not be related to the company. Easy. Not be related to the company. You should have other qualifications as prescribed with respect to law, finance, administration, HR, economics, corporate governance, R&D, and so on and so forth. Sir, if you want to be appointed as an independent director, my dear friend, you should not be a PPE, partner, proprietor, or employee of the audit firm who is providing auditing services to that company, or any legal consultancy firm who is providing legal consultancy services to that company. Also, if whatever revenue your legal consultancy firm is earning, more than 10% is coming from that company only, you are again disqualified. And mind you, when I say partner, proprietor, employee, it is a condition to be satisfied for 3 years, preceding 3 years. Voting rights. If you are having more than 2% of the voting rights, you or your relatives together, you are disqualified. You, of course, cannot become an employee of that company. If you are an employee of that company, how can you be independent director? You cannot be an employee also. Sir, for a non-profit organization, what is the total revenue? Total revenue that comes for a non-profit organization will be in the form of subsidies or maybe donations or subscriptions. Am I right? Sir, if I am a non-profit organization and my donations or subscriptions which I am receiving, total more than 25% is coming from X Limited, then sir, any of the CEO or employee or KMP of my non-profit organization cannot become a independent director in that company. Which company? The company is providing more than 25% of the total donations or subscriptions of my NPO to us. Is that clear? These are your conditions if you want to be appointed as independent director. All right. I agree I am going a little bit faster, but guys, this is a revision class going on, and that is why I'm going a little bit faster. Of course, after this video is over, recording will be available. You can watch it at a slower speed also. That option also will be available for you. So don't worry. For doubts, for queries, feel free to get back. Read this section properly. Understand this section properly. And next, we will go on to the next section. First, go through this portion very quickly. Then we'll go. I'll just keep scrolling first for you, slowly, so that you can then go on to the next section with me. I hope you all are following well. I hope you all have also revised your portions very well, guys. Hope you have your revision schedule made. If you don't have your revision schedule, that also you can message me. I'll help you with your revision schedule also, guys. Okay. Just all you have to do is keep in touch. I'll help you with everything I can. Everything I can. Trust me on that. You and me are working towards the same goal. You should pass. With exemption in the law paper, at least exemption is must. All right. Okay. So here we complete 149. Okay. And now we'll go on to 152. Let's go to section 152.
Okay. 152, appointment of the directors. Very quickly now, appointment of the directors. There are 7 points, my dear friends. There are 7 points. Who will appoint the directors? Everybody should know. Sir, appointment of the directors is done by the shareholders in the general meeting. That, of course, I also know that you know. My question over here is, who does the appointment of the first directors? So remember, first directors, as you can see, you have to verify, you have to check the articles of association of the company. If any name is given in the articles of association, that person will be appointed. If name is not given, but how to appoint, manner has been specified. Follow that manner, and according to that manner, the director will be appointed. Sir, name is also not given, manner is also not given. What should we do in our company? How should we do the appointment, sir? Well, if the name is also not given, manner is also not given, then all the subscribers to the memorandum shall be appointed as the first directors of the company. Understood? All the subscribers will become the first directors. Is that clear? This is the first point. Little bit reference purpose important. Otherwise, point number 6 and 7 are going to be important. 2, 3, 4 and 5, you can see them on the screen itself. If you want to get appointed as a director, you must have a DIN. Without DIN, you cannot be appointed. To obtain a DIN, section 153 is there. So you have to follow 153. So simple points are there in 2, 3, 4, 5. Let me go to 6 1. What is point number 6? Point number 6 talks about retirement by rotation. Now, as you can see on the screen, guys, what is retirement by rotation? If you understand the concept of retirement by rotation, it says what, you know, in a company, so many directors are there, but every director does not have a fixed term. Understood? Every director does not have a fixed term. Now, when a director does not have a fixed term, in that case, how will those directors get retired? How will the directors get retired? So for that purpose, we have this section over here. This section says what? If at all directors are there and they do not have a fixed term, then they shall be eligible for retirement through rotation. They shall be eligible for retirement through rotation. Now, how will the rotation happen? Rotation happens on FIFO basis. Mind you, what basis? FIFO. First in, first out. How will you select the directors? So you have two types of directors: rotational, non-rotational. Okay, so first of all, you take whatever is the total strength of the directors in your company. What is the total strength? Get it all. Minus the independent directors, because we already saw under 149 independent directors, they have a fixed term. Correct? So they have a fixed term, so they are not eligible for retirement by rotation. So minus independent directors, I'll get the figure. That figure which you will get will be known as the total number of directors. Total number of directors. Out of them, 2/3 are going to be your rotational directors. So you will take the 2/3 first, as you can see on the screen, and of the 2/3 you will take the 1/3. Here you should not make a mistake. 1/3 will be of the 2/3. Understood? Whatever is the balance figure, that will continue. They will come up for rotation in the next year maybe. Now, sir, in this 2/3 or in this 1/3, if there is a decimal, then how should we solve the problem if there is a decimal? Well, let me tell you. If there is a decimal in the calculation of 2/3, that is the rotational directors, rotational 2/3, so you will always round it off to the next number. Always means what? Even if it is 6.12, still round off to the next number only. That is 7. And then you will take 1/3 of 7. Understood? And for 1/3 also, sir, if there is a decimal, then what we will do? In that case, you will round it off to the nearest number. Is that clear? The difference, do you understand? First to the next number and then to the nearest number. Is that clear, everybody? Super. Okay. Let's proceed further. Now, as we go further, 1/3, 2/3, I got it. My 1/3 I got. They are eligible for retirement by rotation. Okay. Who will be this 1/3? Or how will you select this 1/3 out of the 2/3? Okay. So for that purpose, have a look at the example over here. See, we have so many directors A, B, C, D and E, and we have the year of appointment also given over here, and their respective age also has been given over here. So how will you select? who should retire. Suppose, let me say, this is the 2/3. These are all rotational directors, so it has to be 2/3. You will take the 1/3 of the 2/3. 1/3 of 5. 5 directors are there on the screen, right? So 1/3 will be 2 point something, 2.33. 2.33. Nearest means 2 have to retire. Who will retire? So who will retire? To understand that, remember, first of all, age is never a criteria for selection. Never. Understood? You will only select on the basis of FIFO, first in, first out. Who is first in? Sir, this is first in. So this will be the one who will go. Total how many have to go? 2 have to go. So one more. Who is the next? 2019 is the next. But sir, there is one more in 2019. Now what to do? 2 have to go. But here in 2019 I have a tie. Now how will you select? Who should go? B should go or D should go? So for that purpose we have 3 options. We have 3 options. What are the 3 options? First, you can ask them only who wants to stay and who wants to go. Removal by mutual consent. Second one is, sir, removal by drawing lots. Lots means lottery system. And third one can be what? You may opt to remove both of them. If the company feels that even if we remove both of them, still minimum number of directors, 3, 2, 1, that criteria is still satisfied, then company can definitely opt to remove both. No problem at all. Understood? That company can opt for that also. Now try to understand one important thing over here, guys. Practically what companies do. Practically, if such scenario really arises, no, what companies do, you know, they will opt to remove both. They will opt to remove both by rotation. So why like that? Because in the next point you will see every person who has retired through rotation under point number 6, retired through rotation under point number 6 shall be eligible for reappointment under your point number 7. Understood? So point number 7 will talk about what? Reappointment. If you can see, reappointment. So now in that particular general meeting itself, we will propose a resolution that we have a director who was eligible for retirement by rotation and has retired through rotation, is willing to be reappointed, and the board also wants such person to be reappointed. So shareholders, what is your opinion? Yes or no? Shareholders will vote majority in favor. Yes, this person, retiring director, will also be reappointed. No problem at all. Let's make it a little interesting. We asked the shareholders, what do you feel? Should this person be reappointed or not? Should this person be reappointed or not? And the shareholders are like, sir, time up. Understood? Time up. What are we trying to say? We are trying to say that if in that particular meeting it was not expressly decided whether we want to reappoint this person or we don't want to reappoint this person, in that case what to do? In that case, when you are not able to expressly decide, the meeting will be adjourned. Adjourned up to next week, same day, same time, same place. Next week, same day, same time, same place. Meeting will be adjourned. Sir, what if that next week, same day, same time, same place is Eid or Diwali or Christmas or Holi or Janmashtami or Mahavir Jayanti or Ambedkar Jayanti or Gandhi Jayanti or Republic Day or Independence Day, or so many holidays are there in India, right? So what the provision says, if that next week, same day, same time, same place is a national holiday. How many national holidays are there in a year? How many? Moon. If you are sitting in Kerala and you are listening to the class, you will understand when I say moon. Moon means 3. Am I right? Okay. So 3 national holidays are there. That is a Republic Day, Independence Day, and 2nd October, that is Gandhi Jayanti. That is our national holidays, and that is where your meeting will be adjourned to the next working day. Is that clear? Otherwise, it will be there on that same day. In that adjourned meeting, we asked our shareholders again. So these are the directors who have been retired by rotation and want to be reappointed, and we also want them to be reappointed. Shareholders, what is your opinion? If they will say in favor, everybody will be reappointed. Not in favor, they will not be reappointed. But if they are saying that Still not able to decide? Well, in that case, in the adjourned meeting also, if you are not expressly able to decide whether they should be reappointed or they should not be reappointed, all the retiring directors will be automatically reappointed. All the retiring directors will be automatically reappointed unless there are 5 exceptions where they will not be automatically reappointed. First one, if you can see 1, 2, 3, 4 and 5 on the screen. First one, a resolution for a reappointment was passed and lost. Lost means what? They did not win. They lost it. Understood? Meaning that it was not in their favor. Then of course they will not be reappointed. Second one, as per the requirement of any law, ordinary resolution or special resolution is a compulsory requirement for appointment of that type of a director. Well, if it is a compulsory requirement, then you have to pass a resolution. Third one says, if a person becomes disqualified under 164, if he is disqualified, he's gone for good. Yes. Fourth one says, if he himself expresses his unwillingness to be reappointed. Unwillingness to be reappointed, person himself says, I don't want to be reappointed. Well, then, okay, you will not be reappointed. And fifth one says, where section 162 is attracted. 162 is what? Appointment of directors to be voted individually. You understand? Appointment of directors to be voted individually. What does it mean? Remember 162, unanimous resolution, then ordinary resolution, then you can do the appointment of all directors together. Correct? That is 162. So if 162 is attracted, then he will not be reappointed. Otherwise he means all of them will be reappointed. Is that clear? Hold on. So this is your 152. Take. I'll just bring it up on the screen for you again. First have a look at retirement by rotation point. Then I'll take you to the 7th one. Okay. Have a look, note it, mark it, and then we'll proceed very quickly. Done? Alright. Let's go to another important section that I am taking up over here. Let's go. Sure. Loan to director. Wait, first I'll take 186 for you. Then we'll go to 185. That will be easier. Law 186 talks about loans and investments by company. Okay. So now here we are going to talk about a company who is dealing into loans or investments. Okay. First of all, can a company deal into loans or investments? Of course, yes. Why not? Why would you even say no, sir? Right? So what does the provision say? Let's understand the provision. Provision says, if at all you are a company dealing into loans or investments and you are taking this loans or investments from a bank or any NBFC, non-banking financial corporations we call, right? If you are dealing into loans or investments from any bank or any NBFC or so, this section will not apply for that. Understood? Why? This is where two companies are there. and two companies are dealing into this intercorporate. Two companies means it is an intercorporate transactions. So what the first line or the first point over here says, pay attention. A company shall not make an investment through more than two layers of investment companies. Now immediately a question should pop up in your mind, sir, not is given, meaning there is a restriction over here for a company to make investments through more than two layers of investment companies. Sir, what do you mean by investment companies? I'm taking you at the bottom of this section. If you already have downloaded these notes, you will have it, right? So what is this? At the bottom of the section, if you come, you will find it. Investment companies means what? Investment company means company whose principal business itself is investments, like acquisition of shares, acquisition of debentures, and this company will be principally deemed, it will be engaged in what? Investments. Like 50%, how much? Minimum 50% of the total assets or income derived from investment business. Minimum 50% of the gross income is from investment business. So this is what we call as investment company. Understood? Let's come back. What does the point have to say? So if you can see the point, all the important points, important words that you need to read and revise, that I have already highlighted over here. So what does it say? Company shall not make investment through more than two layers. Okay. Provided that this section will not apply, in which case, sir, first of all, a company from acquiring any other company incorporated outside India, I am making investments, not more than two layers, okay, within two layers. But if at all, we are talking about a company which is incorporated outside India and in that country, it is allowed for more than two layers, then such other company can definitely make investments through more than two layers. Yes or no? We cannot put our laws on everyone. So that is number one exception. And second one, if at all you are a subsidiary company you are allowed from having any investment subsidiary for the purpose of meeting requirements under the law. So you are basically complying with the provisions of the law. So it is allowed for you. Okay. Provision says what? No company shall directly or indirectly enter into any leagues transaction. Sir, what is leagues transaction? Leagues means what? L-I-G-S. So many times this word we are going to come across under this section itself. So I have made it a short form over here in the form of leagues, where L stands for loans, investments, guarantees or securities. Understood? Loan, investment, guarantee, security. For those who do not know, I will tell you, I'll bifurcate this like this. This is direct and this is indirect. Understood? Guarantee, security is something I am giving for someone. So that is an indirect transaction. Loan I am directly taking from you, or investment I am directly doing it with you. So that is my direct transaction. Why I am telling this, we'll come to know shortly. So what does the provision say over here? Provision says no company shall directly or indirectly enter into any leagues transaction. Then there is a point over here which I am showing you and then I will cancel it. When we talk about any person, limit of the transaction, what is the limit? Not more than 60% of the net worth, paid up share capital, free reserve, securities premium, or 100% of free reserves and securities premium, whichever is higher, whichever is more. This is the limit. Understood? 60% of net worth or 100% of your free reserves and securities premium, whichever is higher. That much leagues transaction you can enter into, no problem. That much you can enter into, no problem. But when I'm talking about the leagues transaction which are entered into by any person, when I'm using the word person, I am not including this person. I am not including employee of the company, because about employee I am already going to talk about in 185. Understood? And that is why I am removing this from here. Not required for me. If I want to go beyond 60% of net worth or 100% of reserves, whichever is higher, if I want to do leagues transaction beyond that, definitely I can do. For excess, I have to pass SR in GM. SR in GM. Acha, SR in GM also they are saying is not required. If you are doing the leagues transaction exceeding the limit, But with whom are you doing? You are doing it with your wholly owned subsidiary. Wholly, 100% is with me only. Then no SR in GM required. If it is your joint venture company, then also no SR in GM required. This was the only important provision in this section, first of all, that you had to understand. One more is there. I will show it to you. Between them, all the provisions are very simple. Okay, first go through this provision, try to understand it, try to note it down. Understood? Get clarity about it, and then we'll proceed to the next one. Okay, very quickly, please. Done, guys? Okay, lovely. See, balance points, simple points are there. We'll quickly run through them. Full disclosure you have to do for all the leaks transactions that you have entered into. Okay, prior approval of all board of directors. Unanimous resolution is required. Please make a note of this resolution. Board resolution, that is unanimous requirement is there, and prior approval of PFI concerned, where any term loan is existing. If you are having any term loan, existing term loan in the company, long term loan in the company, then PFI, from where you have taken that loan, you have to get an NOC, that is a prior approval from them as well. This NOC or prior approval from PFI will not be required if you are within your limits of 60% or 100%, whichever is higher. That was the limit, right? So if you are within your limit, then there is no problem. If you are crossing that limit, well, problems in life start when we cross limits. Am I right? Anyway, next what they are saying, sixth point is for brokers. For brokers, they are saying companies which are registered under section 12 of SEBI, that are brokers. For them, they shall not take intercorporate loans or deposits exceeding the prescribed limit under SEBI. So we don't have to do anything about that. Seventh point, again one relevant point. When we are doing intercorporate transactions, now try to understand now. See, these are two companies. Okay, these are two companies who are doing an intercorporate transaction. This is A, this is B. Okay, A is giving loan or investment or guarantee security in B. Okay, now when A is giving any loan to B, when B will repay, this is loan. So when the repayment will be done, it will be done with interest. Yes or no? With interest. Now what happens over here? A says, B, you are my company only. Why should I take interest from you? What to take interest from you? Forget it. Let it be. Yes or no? This is what they say. But that is wrong. That is wrong. Why? Because the loan which you are giving, no, over here, that company, Mr. A company, that is not your money. That is company's money. Yes or no? If you would have not given that loan to B, you would have invested it somewhere. Yes or no? Somewhere you would have invested it somewhere. Let's take the worst of the possibilities, that if you are not giving a loan and you are investing it like absolutely negligible returns, like in government securities. Government securities, absolutely negligible returns are there, but 100% safety will be there. Yes or no? Low risk, low returns. So for them, what they are saying, if you are giving any such loans to be, charge interest from them. And how much interest you will charge, assume that you have invested money in government security. Government security, when you invest money, there may be for a fixed term, like 1 year, 3 year, 5 year, or 10 years. Understood? Whatever is the rate of interest that you will earn for this investment, it will be the minimum of every possible other ways. Yes or no? That much at least you should charge from B. That much at least you should charge. But sir, I have given loan to B for 9 years, not 10 years. Then what should I do? Take whichever is the nearest. Simple as that. Take whichever is the nearest. Take that rate of interest. Sir, but I have given loan for 4 years only. Now 3 is also near and 5 is also near. Now what should I do? Well, then you are missing my point. If you are getting this question, then you are missing my point. What did I say? Minimum rate of interest you have to charge according to this security investment. Minimum means what? You be conservative, no? Whatever interest you could have earned if the investment was for 3 years, that much you charge. Minimum. You can charge more also. There is no problem. Understood? Now let's come back over here. See what the point says. No loan shall be given at a rate of interest which is less than the prevailing returns, prevailing yield of 1, 3, 5 or 10 year government security closest to the tenor. So minimum that much you should get. No company which is in the default of repayment of deposits or interest shall give any leaks when such default is still existing. Okay, fine. Maintain a register of whatever leaks related transaction you have entered into. Simple point. Register shall be kept open. Extracts may be provided to you on payment of certain fees. Those who do not know, let me tell you. Guys, make a note. We are in the directors chapter. We are talking about this taking extracts or copies of the register under section 171, under section 186, 189 and 190. Clear? Understood? Easy. What we have to understand over here, I'll swap these numbers. Why? I will tell you. 190, 186. 4 places in the directors chapter where we are maintaining some registers or copies and they can be demanded and extracts have to be provided. These two, 171 and 190, which you are maintaining, they will be provided to the members free of cost. And these two will be provided on payment of certain nominal fees as may be prescribed. Is that clear? Understood? These are the small things that you have to note. You have to make a note. Understood? Otherwise, answers to you will also know. I'm pretty sure. 11th point, that is another important point. What is important, I will tell you. The important thing is only the first line to understand properly. This first line is important. This section except subsection 1 is not applicable to. Okay. What is the first line? Again. This section is not applicable to. This section, entire section is not applicable to the following. Not applicable to A. Not applicable to B also. B. Okay. So A and B, this section is not applicable. But even if this section is not applicable, I am saying except for subsection 1. Meaning subsection 1 will apply. Subsection 1 will apply. Understood? Except, what is subsection 1? Not more than 2 layers of investment companies. Investment which you are doing, not more than 2 layers of investment companies. That one, first subsection will apply. Apart from that, nothing in this section will apply to banking company, insurance company, housing finance company, or any company where we are saying providing infrastructural facilities to any investments made by investment company. Or any further issue of capital, section 62, CA enter. Further issue of share capital which you are making, like rights issue, ESOP, FPO, yes or no? That also not considered to be an investment over here. Then any investments by or with NBFCs, because their RBI Act is already involved. So these are exceptions where this particular section will not apply. Understood? Central government may make rules, and last, penalty for contravention. Technically, guys, if you understand, no, I'll tell you in section 186, point number 1, point number 7, point number 11. These are the 3 important points. 1, 7, 11. If you understand these 3 points properly, you have conquered 186 easily. Is that clear? Yes. So I'll just keep 1, 7, 11 for a brief time in front of you. Make sure you have them in your notes as well. 1711. 1711. One seven 11. Quickly. Done? Very quickly, let's go to 185 now. 185, loan to director. Simple question to you. Can a company give loan to director? Can a company give loan to director? Yes or no? I'm pretty sure 90% of the students sitting over there are nodding their head. Yes, sir. Right? And let me tell you, your answer is wrong. Can a company give loan to director? Answer is no. Sir, we have seen in our articleship, yes, companies are giving loan. I'm not saying companies cannot give loan to the director. No. Mark my words. My question to you is, can a company give loan to the director? Your answer has to be no, sir. No, sir. No company shall directly or indirectly give any loan to any director. Any director or any firm in which that director is a relative or he has a partner or a relative or anything. No. That is the provision. But of course a company can give loan to director, but that is as per the exception. Exception says what? SR in GM. Whose money are you going to give to the director? You are going to give the money which belongs to the shareholders, right? Ask the shareholders. Pass SR in GM. Or if at all you are saying that the loan which we are giving it to the director of the subsidiary company. We are giving it to the director of the subsidiary company, but that money is going to be utilized by him for business purpose only. Okay. Utilized for business purpose. Okay. No problem. Allowed. Sir, but having said that, I will not be required to pass SR in GM also. I want to give loan to director, but I will not be required to pass SR in GM also. I can directly give loan to director. When as a company I am extending this service of giving loans. You want loan? You want loan? No. You want loan? I am extending this service to all my employees also. So when as a company I am extending this service of giving loans to all my employees also, it's okay. I don't need to pass SR in GM. Or if I say, I am a bank. Oh, in the ordinary course of business, your business itself is providing loans then, right? For you, how can I stop? Yes or no? For a bank, your business itself is providing loans, banking company, no problem. But one condition. When you are giving loan to director, same like we saw in 186. What? The rate of interest charged should be not less than 1 year, 3 year, 5 year or 10 year yield that you will get for your investment in government securities. That much minimum we should earn. Then you can provide whatever loan to director you want. We do not have any problem. Is that clear? Everybody? Yes or no? Easy. So that was a relevant and important point for us over here. Clear? Next, Next, C and D point, just try to understand very clearly. Loan, investment, as I told you, they are direct transactions, and guarantee security are indirect transactions. Company, transaction with wholly owned subsidiary, wholly owned. company and transaction with wholly owned subsidiary, direct as well as indirect. Direct as well as indirect. No problem, sir. Loan, investment, guarantee, security, all transactions allowed. But when a company transaction with subsidiary only, not wholly owned, subsidiary only, then only guarantee security. No loan investment transactions allowed. Understood? Getting my point? So if I am giving a loan or investment or guarantee or security to the director of my wholly owned subsidiary who is going to utilize for principal business purpose only, no problem. You can give it because it is wholly owned subsidiary. But if you are giving it to the director of your subsidiary company, subsidiary, not wholly owned, subsidiary only, you can only give it in the form of a guarantee or security, not loan or investment to them, because there are other investors also. And important point for you guys is penalty for contravention over here. You need to understand the penalty which is given over here. What is the penalty given? If you contravene the provisions of this section 185, then remember, penalty on company, fine is there. Penalty on the officer in default who is giving that loan without complying with the conditions. And same penalty will also be imposed on the director who is taking that loan. You are also director of same company, no? Understood? I am penalizing the officer who is giving you that loan. You are also the director of that same company. It is your responsibility also to make sure that you do not violate the conditions of this section. Am I right? How can you violate the conditions of this section then? How dare you? Can you dare? You cannot dare. And that is why you will also be penalized. Clear? That is your 185. Okay? So that you have to understand in 185. I think 185 is pretty much clear now. Two more sections in directors I am taking up, 88 and 97. 188 and 197. Okay. That is related party transactions and managerial remuneration. Okay. These two sections I will take up and then we'll switch on to some new chapter for revision quickly. Alright. So next we have to go to 188. 188. Here comes your 180.
Section 188 on your screen. Can you see that? Related party transaction. See, first of all, answer my very simple question. Very simple question. Okay. If I am entering into a transaction with some related party. So section 188 attracted. Yes or no? Yes or no? Your answer is yes. And let me clarify your doubt over here. The answer is wrong. Why? Because for 188 to be attracted, here it should not be me. It has to be a company. You are studying Companies Act. You are studying Companies Act, am I right? Excuse me. So if you are studying the Companies Act, your first party over here who is entering into the related party transaction has to be a company. Company is entering into a transaction with some related party. Yes or no? So there is a transaction over here. This transaction is of the nature of ALASUS, Salas us type of a transaction. So whenever you say a company is entered into a transaction with related parties, so 188 attracted? No, man, no. 188 does not get attracted in every transaction. No. 188 is very specific. It says, first of all, there should be a company. There should be a related party. Yes or no? There should be a related party. Between them, you should have a Salas us type of a transaction. If one is attracted, if two is attracted, if three is attracted, then 188 is attracted. Then only 188 is attracted. Do you understand? Yes or no? 1 second, I'm unable to scroll this. Sir, 188 is attracted. Yes, 188 is attracted. So what? So what? So nothing. 188 is attracted. So OR in board meeting and OR in general meeting. Required or not, that you have to decide. Here, you don't even have to decide because this is compulsory. Required. OR in BM, always required. Question is about OR in GM required or not. OR in GM, well. Conditions apply. OR in GM, what we say? Conditions apply. Conditions apply means what? May be required, may not be required. You have to check the transaction value. What is Salas Us? Salas Us is the type of transaction. You have to check the transaction value. If the transaction value is more than the given limits, then OR is required in general meeting also. If the transaction value is not more than the given limits, OR in GM is not required, but OR in BM always required. Is that clear? Understood. Am I right? Am I clear? Okay, guys. So this is what you have to understand when we talk about 188. If this chart which I have drawn over here, this also if you understand, your 188 becomes really easy. Okay. Yes. Okay. Understood. Same thing I have given in our notes also, so you can see it from the notes also. Here it comes. Remember, 2 points given in red color over here. If at all, we are talking about OR in GM, required, not required and all. If the company is entering into a related party transaction, okay, I am a part of that company itself. I am a part of that company itself. I am a shareholder of that company itself. And the transaction which they are talking about, I am one of the related parties in that transaction. I am what? I am one of the related parties who is involved in that transaction. In that case, when they are talking about passing a resolution, I cannot vote. That is given in the first point, note number 1. I will not be allowed to vote. Logical, no? If I am only the related party and I am only voting, my vote will be biased. Right? Second point says, but sir, if at all 90%, 90% of all the members are related parties, well, then there is no point in stopping anyone. Everyone can vote. Understood? Sir, how to remember these limits? Salas us. Well, to remember the limits, let me give you a very easy way to remember. First, remember Salas us. Okay, Salas us. Okay, so first I'm taking S1 and I'm taking this as S2. It talks about sale or purchase or supply of what? Goods, material. Then same sale, purchase or disposal. Disposal meaning property. Third, we are talking about A. Okay, so this is your S1 gone, S2 gone, now A. A talks about what? Sale, purchase, supply or disposal of goods or material or property comes your A for with the help of agent. Understood? Then you have for leasing. Then you have A for appointment. Appointment of what? Appointment of any person at office or place of profit. Sir, what do you mean by office or place of profit? This means at the top management level, like director level designation. Understood? How do you come to know? Sir, they have talked about place of profit, meaning we are going to give them certain part, certain place in the profit of the company, certain percentage of the profit of the company. Okay, so that is how we come to know. Then you have S for services. Okay, and U left, U for underwriter's subscription amount, underwriter subscription. Okay, these are the transactions. Now limits are very easy. All you have to do is identify whether it is a P&L transaction or a balance sheet transaction first. Like goods, material, P&L, property, balance sheet. Here, if it is goods, material, P&L. If property, then balance sheet. Leasing, your P&L, it is an expense. Correct. Here you have services. Services meaning P&L. Yes or no? Income, expense. So this is my P&L balance sheet bifurcation. Understand? If it's your P&L, this is your balance sheet item. Okay. If it's your P&L item, you have a standard limit 10% of turnover. Balance sheet item 10% of net worth. Finish. Finish. All P&L items 10% of turnover. All balance sheet items 10% of net worth. That's it. You can check it out over here. See. I've already highlighted the limits for you. You can see the limits also. Goods material, P&L item, turnover, property, balance sheet item, net worth, and so on and so forth. Only remember, when we talk about appointment of a person to office or place of profit, in that case, more than 2.5 lakhs per month, if you are giving remuneration, can you give? You give 25 lakhs. I don't have a problem. If you are giving more than 2.5 lakhs, who are in GM required. When that person to whom you have appointed is your related party. And for underwriter subscription, more than 1% of net worth, if you are giving, that underwriter is your related party. Well, yes, who are in GM required. Sir, I have not passed OR in GM. Or maybe I have not passed OR in BM. Then what to do? Here. I will say section 188 has been contravened. 188 says OR in BM to be passed, OR in GM to be passed. You have not passed. So contravened. Okay, contravened. So what? So nothing. No problem. It happens. Transaction was very urgent. We did not have time to call for a board meeting or general meeting. So we had to do it. What to do? No problem. Relax. What to do? Very simple. Within 3 months, get it ratified. If it is BM, get it ratified by board of directors. If it is GM, get it ratified with the shareholders. Same within 3 months. Understood? If ratified means what? Ratified means subsequent approval. Subsequent means why subsequent? Subsequent because transaction is already done with related party. And then you are going for getting an approval. So that is why we call it get it ratified. If it is not ratified, it will be voidable. If it is not ratified, it will be voidable. Is that clear? Easy? I hope this is clear now. Any doubts? Any questions over here? Thorough? Shall I proceed? Okay. Penalty for contravention for listed companies and unlisted companies only. Why? Because section won't apply to private companies. Okay. This is major what you have to see in 188. Easy. I'll scroll through the section once for you. Those who are not having the notes, you can take screenshots, please. Yes. Those who are having the notes, you can just go through the notes also. Is that clear? One more section from director's portion we'll take. That is 197. Okay. I'll take up 197. You can see 197 on the screen, guys. What does it say? Overall maximum managerial remuneration and managerial remuneration in case of absence or inadequacy of profits. So, guys, to understand this section very properly, what I have done, overall maximum managerial remuneration, this I have given it as part 1. After and whatever is there, managerial remuneration, we have given it as part 2. We'll talk about it afterwards. Okay. Right now, we are not talking about it, so I'm not even willing to highlight it. Forget it. Okay. Yeah. Okay. Right now, we are only talking about the part 1. Let's talk about part 1. This section, it's as it says, private companies, government companies, forget 197. You government companies have that pay scales according to which they pay remuneration. Private companies, it's a private company, your money, your company, you pay whatever you want to each other. Understood? Other companies, public companies. Directors' remuneration will be divided how? That is given over here. Everyone with me, chalo, I'll remove these markings so that I'll do it fresh over here for you very quickly. We are talking about directors' remuneration. Which directors are we talking about? First case, we are talking about the MD WTD manager. And here we are talking about directors other than MD WTD manager. If I talk about directors other than MD WTD manager, I will ask them a question. In your company, do you have MD WTD manager? Yes or no? If your answer is yes, company has MD WTD manager, then maximum 1% of net profit. And if your answer is no, company does not have MD WTD manager, no, you do not have, then maximum 3% of net profit. Clear? Sir, what if the company has only one MD WTD manager? This is for the MD WTD manager himself. If there is only one person at that designation, maximum 5% of net profits. And if company has more than one people at that designation, then we'll give them what? Maximum 10% of net profits. This is what we have as a remuneration for directors. Understood? Without MD WTD manager, other directors will get up to 3%. If MDW manager are there, then they will bear the maximum risk. So higher the risk, higher the returns for them. For you, only 1%. Understood? For MDWTT manager themselves, how much? We have 5% and 10%, depending on whether it is only one or more than one. Acha, most important thing. Most important thing. This is not per director. This is total limit, aggregate limit. Is that clear? So don't get confused over there. Then we talk to subject to what? Maximum 11% total. 1% or 3%, 5%, 10%, whatever you want to give, you give. Total will be not more than 11% of net profits. If you want to go more than 11%, pass SR in GM and then you can go. Understood? This is the first point and the important point that you have to understand the table. Okay. Rest 4-5 points, simple points very quickly. Remuneration will be what? Inclusive of all the payments. You give payment in different names. Everything is treated as a part of remuneration. It should not be more than the limit. Except for sitting fees, which you will get only if you sit for the meeting. And if the director has provided any services in a professional capacity, like if you are going to be chartered accountants and you are providing any services which are not in the capacity of a director, but in the capacity of an independent chartered accountant, for which you are going to raise an invoice on the company, then that will not be treated as a part of your remuneration. Understood? Otherwise, it will be 1, 3, 5, 10, subject to maximum 11% of net profit of the previous financial year, audited financial statements. So what if it is my first year only? Then what? We have schedule 5 also, no? Patience. This is what? This is overall maximum how much remuneration I can give you. Normal provision. Okay, have a look over here. Now, I have my net profit of previous financial year. I have your percentage of remuneration. So in the beginning of this year itself, approximate figure at least, I know how much remuneration I'm supposed to pay to you. Am I right? I can pay you lump sum also. I can pay you monthly also. I can pay you partly lump sum, partly monthly also. So basically it depends between company and the director to decide how they want to give the remuneration. Amount is fixed. You can decide and give as you want. Net profit will be determined as per section 198. This point, understand? If the company has to pay some remuneration to you, but the company has paid some excess remuneration, little bit more excess remuneration, or company has to then require to recover that remuneration from you. But company feels you are the director of the company only, and your remuneration is in lakhs and crores maybe, and very nominal amount, 2, 5, 10, 15, 20,000, 50,000 is there. Nominal amount, small amount. How should we ask you for such a small amount? Can we recover? Otherwise, we say, forget it. When you are the director of the company, forget it. It's okay. Can we do that? Answer over here is no, sir. No, you cannot do that. The company shall not waive off any amount which is recoverable. No. Cannot waive off any amount. You want to recover, you want to waive off, you don't want to recover the money which is recoverable, you don't want it. Okay, fine. Fine. No problem. No problem. Whose money it is? Shareholders' money, no? Pass a special resolution in general meeting. And do this within 2 years from the date of default. If the shareholders say no problem, okay, fair enough, no problem. You waive it off. Otherwise, you have to demand that money from the director. Yes or no? You have maximum 2 years period. You can demand it tomorrow also, day after tomorrow also. Maximum 2 years period is there. But remember one more thing. If at all you have taken loan from banks or PFIs, you have to make the repayment of the loan. You are saying, oh, bank, oh, PFI, I don't have money, no funds. Okay. And here you are saying, director, I have to recover money from you, director. Don't give, it's okay. Bank, PFI, they will raise objection, no? Yes or no? That you have to give us the money, and you are saying, I don't have the money, and here you have to pay the money, and here what are you doing? Where you have to pay the, where? Right? At the time of payment, you are saying, I don't have money. At the time of recovery, you are saying, don't give money. Is that fair? No. So what they are saying, if you have defaulted in the payments to any banks or PFIs, you need to get an NOC from them. A prior approval is required from them. Is that clear? Yes or no? This is your part 1. Part 1. Easy? Easy peasy? Everybody? I'll keep it in front of you. Only overall maximum managerial remuneration. Okay. Part 1. Get through it very quickly first. Then we'll go to the next. I reckon you're done. Let's go to the part 2. Sir, what is the part 2? Part 2, guys, as you can see, managerial remuneration in case of absence or inadequacy of profits. So, guys, profit is there, maybe not there. Absence of profit. Loss. So, loss is there. So, how to give remuneration in case of loss? If profit is there, you are giving certain percentage of profit. What if there is a loss? Then what to do? Okay, that is one question over here. Another question, what if there is inadequacy of profit? Sir, what do you mean by inadequate? Inadequacy means insufficient profit. What is insufficient? Or what is sufficient? Can you define sufficient or insufficient? Even if you say profit is 100 rupees only, you can still take 10%, 11% of that. No? How will you define insufficient profit? Correct. So when understand the language of the law, then the law will become interesting for you. When they are talking about inadequacy of profits, what are they actually trying to say? Here, they are trying to say that when I did income minus expense, I got the profit figure. Profit is there. But from this profit, I have to deduct tax, deduct appropriations like dividends or anything. Yes or no? When I do all that, appropriations and all, after that, there is a loss. Yes or no? After that, there is a loss. So actually, when I see here, profit is there. But profit is not enough to make the payment of the appropriations also. Understood? After making the payment of appropriation, there is a loss. So this is known as what? This is known as inadequate profit. Inadequate profit. Is that clear? In this case, what should you do? So here the provision says in such case you have to go to the table of effective capital. This is your table of effective capital. What is effective capital table say? Very simple. First, you calculate your effective capital. Okay, your share capital plus reserves and surplus plus long-term liabilities that you have. Yes or no? Exclude your revaluations, exclude your what do you say, short-term liabilities or your working capital loans or whatever is there, preliminary expense, debit balance, P&L. Exclude all those things. Remove. Then you will get your effective capital. Now what is it? Is it positive or negative? If it is negative, from negative to less than 5 crore range, or 5 crores to 5 crores and above to 100 crore, 100 and above to 250, 250 and above. Check the range of your effective capital. Depending on that range, your remuneration of the directors will be fixed. But important thing, in the column number 2, we are talking about remuneration of MD WTD manager. In column number 3, we are talking about remuneration of other directors of the company. Okay. Here, what is important is the limit is given as you can see, depending on the range, 60 lakhs, 84 lakhs, 120 lakhs, 120 lakhs plus 0.01% of the excess amount, 12, 17, 24, 24 plus 0.01%. So that is simple. Important is these limits are per director, per. That 135, 10, maximum 11 was not per director. This is per director. Understood? This is the limit per director in case of absence or inadequacy of profit. And even if you want to give more, you can pass a special resolution and give more also. There is no problem. Understood? This is the most important thing in the second part which you have to understand. Other points are pretty easy. You'll be able to do it on your own. If you have questions, you can get back to me. Understood? Everybody clear? All right. Super. So that is important portions from the directors chapter that we have to study. So we'll stop directors over here. If you have any questions, you can get in touch with me. This is the WhatsApp on which you can send your messages with your name and from where you are. So I should come to know with whom I'm talking to. You can WhatsApp, only WhatsApp. Don't call on this number. Just WhatsApp on this number and I'll get back to you. Understood? Next, we will start up with a new chapter for revision. All right. So I hope this is clear. And we start up with the new chapter in just a minute. Let's do prevention of oppression and mismanagement. 241 to 245. Very small chapter, but important portions of this chapter. I'll revise it with you very quickly. First of all, understand the meaning. Prevention of oppression and mismanagement. Mind you, the spelling, make sure you understand the spelling properly. It is not the operation. Okay. Do not make this mistake in exam. It's not operation. It is oppression and mismanagement. What is this chapter all about? Well, you can just focus on this diagram from my book. If you understand the diagram very clearly, you will understand that this is a diagram wherein you can see all the faces, all the bodies in blue and just one of them in gray, right? This chapter is about the person who is in gray over here. What is the chapter all about, sir? In this chapter, we have to understand that this one person is the minority as against all the other people who form a majority. And our job over here is to protect the interest of the minority. Understood? There are so many cases where you will see oppression happening against the interest of minority or mismanagement happening against the interest of minority. When you see this oppression happening, when you see this mismanagement happening, what you need to do is you need to make sure you protect the interest of the minority. Understood? Now, what is oppression? What is mismanagement? I've given the meaning over here for your understanding. Oppression, as you can see, oppression means where the affairs of the company, whether it is past affairs or whether it is present affairs, either or past or present affairs are prejudicial. Affairs of the company are how? They are prejudicial to the interest of the public, to the interest of the company, to the interest of the applicant himself. Other side, we talk about mismanagement. So what is mismanagement? Mismanagement means when there is a change, a material change, which has already happened, or maybe it is supposed to, it is going to, it is proposed to, it is apprehended that it is going to happen. When there is this kind of a change in the management of the company, in the ownership structure or the membership structure of the company, and we feel that if this change will happen, it is going to be prejudicial to the interest of the stakeholders. In that case, point number one, important thing to be noted is who will make application for oppression mismanagement? Member, as per point number one. Then application can also be made by central government as per point number two. So two people have the authority to make application. It can be member, it can be central government. Why will central government make an application? For that, you have to go to subsection 3 where we have given the highlighted portion that A, B, C, and D. 4 reasons are there where central government is going to make an application to the tribunal to go and conduct an inquiry and submit a report back to CG. Understood? What are the reasons? First, if the central government feels, see, I have highlighted that a person from the top management is what? Guilty of fraud or misfeasance or negligence or committed a default in carrying out his obligations or functions or involved in any breach of trust. In that case, what is it? In that case, that is first point over here that you have to understand for central government will make application if CG feels anything out of this is attractive. Next, if CG feels business, the business is not being conducted or has not been conducted with sound business principles or prudent commercial practices. If CG feels this is there, business principles are not followed, then central government will make an application to the tribunal. If CG feels that the company is being managed in such a way by a person which is likely to cause any injury or damage to the interest of industry or the business, then also what the provision says over here, it is necessary. What is necessary? Central government will make an application to the tribunal. Understood? And lastly, if CG feels that the business is being conducted with the intent to commit a fraud, that is to defraud, in that case also CG will make an application. So 4 reasons are there where CG will make an application to the tribunal. Okay, what tribunal has to do? Tribunal has to do the inquiry and then make a report and give it to CG. And according to the report, tribunal has to specify that as per the opinion of the tribunal, whether that person in the top management about whom we are talking about is fit and proper to hold the office of the director or not. Understood? So that you have to write over here. This is easy. Okay. Then let me take you to how many members are required to make an application. One, we saw CG. 4 options are there. Any 4 reasons, anyone CG feels it is attracted, CG will make an application to the tribunal. Members can also make an application. How? Now, for verifying how many members can make an application, we have to verify it on the basis of 2 things. One, on the basis of number or on the basis of value. Understood? Either on the basis of number of members or value holding of the members. When you talk about number of members, we'll say 1/10 or 100 members, whichever is less. But when I said about value, I will say members who are holding 1/10 of the issued share capital. Understood? This is how we compare them in value. See over here. As you can see, 1/10 or 100, whichever is less, or 1/10 of the issued share capital. This is if a company has share capital. Then it will have shareholders. If there is no share capital, then members will be there. Shareholders will not be there. It will be 1/5 of the total members. Easy enough? Okay. But not necessary that these many members always should be there. If your reason is very genuine, tribunal may accept application by lesser number of people also. Is that clear? This is to be understood important. 242 is powers of the tribunal. Very simple powers are given over here. I have given them in the notes also. You can simply read with them. It will be very easy for you. You won't need my help there. 243 is where little bit of help might be needed, I think. Why? Because why I'll tell you why help will be needed. See, when you talk about section 243, no? 243 is what? Under section 242. Tribunal has exercised its powers. Correct? Now, by exercising the powers, if tribunal has modified any agreement, terminated any agreement, anything like that, tribunal has done. In that case, also some action may be taken by the tribunal. Yes or no? Central government told the tribunal, check, verify, inspect, inquire, and give me a report. So tribunal feels person is not fit and proper to hold the office of the director. Correct? So now both the cases can be there. If member made an application and tribunal passed an order, what order can be there? If CG gave an application and tribunal passed an order, what order can be there? And if the order is not complied with, what can be the consequences of that order? That we have to see under 243. Why I said you will need my help? Because when you read 243, no, you should learn the art of reading. It comes under 243 1. What is this? 243 subsection 1. Under subsection 1, you have clause A. Under subsection 1, you have clause B. Then you have 243 subsection 1A. And then you have 243 subsection 1B. Try to understand. When you are mugging up the section, this is where you will make a mistake. When you are mugging up the section, you will be saying what? 243 1A, 243 1B, 243 1A, 243 1B. Understood? And that is where your 1A, 1B, 1A, 1B will get confused. Try to understand. The section is divided in two parts. 243 subsection 1, clause A and clause B talk about when member has made an application to the tribunal and any order is being passed by tribunal, what will be the order? And 243 subsection 1A and subsection 1B, that is this part, talks about when central government has made an application to the tribunal, what will be the order of the tribunal? Understood? This much is clear. Very simple. I'll make it for you in the form of a chart over here. See, have a look. Try to understand this chart and take this down if you require. Yes. Under subsection 1, I have given A and B as you can see, and under subsection 1A and 1B, separate points we have given. Subsection 1, clause A says no CLOO, compensation for loss of office. If the director's office is lost as per the order of tribunal, no compensation will be given over here. And if you are an MD, manager, director against whom the order is passed, you are disqualified for 5 years. When central government made an application under 1A, the order comes over here that if tribunal feels the person is unfit, not proper as per the order of CG, as per the order of tribunal, first of all, tribunal will give this order to CG. This person will also be disqualified for 5 years, but he may be appointed during that span again, but with prior permission of CG only. That is clear? 1. And under 1B, what they are saying? 1B, again, central government made application to tribunal. So if tribunal feels that person is unfit, then again, no compensation for loss of office in this case also, and you will not be disqualifying him or removing him unless central government has provided him with a reasonable opportunity of being heard. Now, if you pay attention very clearly, you will understand, sir, there is a point of disqualification over here and point of disqualification over here. Yes or no? Do you understand this? Now, by understanding this, what I'm trying to say, you are talking about subsection 1, clause B, and you are talking about subsection 1A. Why am I talking about them? 1B and 1A. Because in the next subsection, that is subsection 2 of 243, they have talked about penalty for contravention of 1 clause B and 1A. 1 clause B and 1A. Is that clear? Super. Okay. Next, let's go to class action suit. Okay, but wait. Not so fast. I'll give you a minute or two. Maybe you can just take this down. Take it down at such a place in such a way that it helps you for revision, guys. Quickly. Are we done? Class action suits. So what is a class action suit? Guys, let's understand the concept of class action suit over here. What is a class action suit? If you understand, guys, what is a class action suit? See, class action suit, first understand the concept. Class means group of people. Yes, a group. Class means a group. A group of people are coming together. Why? Why they are coming together? To take an action, one action, by filing suit. So what happens over here? Too many people are involved. United we stand and divided we fall. You might have learned that, right? Like this one single stick, and you can easily break it to pieces. But if there is a bunch of them, if there is a bunch, ah, ah, not possible. Not possible, right? So what do you understand over here? This is something you have been learning since I don't know how young you were. Am I right? So that is the power of class action suit. If I file a case against a giant company, maybe I might not survive. But if 100, 200, 500 of us file a case against a giant company, but everyone coming together and filing a case for a single reason, a case for a single reason against a company, it's all a. Understood? In that case, definitely the case will become more and more powerful. Am I right? So, for filing a class action suit, how many members are required or how many depositors are required? Even depositors can come together and file a class action suit. So, how many of them are actually required? Let's have a look. When we talk about members or depositors, provision says if you are a company having share capital, at least 5% of the shareholders or 100 shareholders, whichever is less. So, this is in numbers. Or we will compare it with value. Value means those who are holding 5% of issued share capital if you are an unlisted company, or 2% of issued share capital if you are a listed company. Understood? These many should be required for filing this many should be required for what? Filing a class action suit. Not having share capital, same 1/5 of total members. In case of depositors also, 5% or 100, whichever is less, or in terms of value, again 5% to whom the company owes 5% of the debt of the company. Understood? So that is pretty easy. These many members are required to file class action suit. Okay, chalo, they came together and they filed a class action suit. Now what? Now, will the tribunal accept it? If there are so many members, will the tribunal accept? No. Tribunal will ask them first, what do you want? You tell me first, what do you want from the company? So they can say three things. Number one, tribunal, stop the company, 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 stop. Stop means restrain the company. Why restrain? Company is doing something which is ultra vires. Company is doing something which is not allowed as per the law. Company is doing something which the shareholders have rejected. Company is doing something which is beyond the memorandum and articles of association. So you restrain the company from doing that. That is my first demand. My second demand can be give me money, give me money, give me money, give me money, give me money. What does it mean? Claim damages. Claim damages or compensation from the directors or auditors or experts or consultants, anyone. on the basis of whose report we invested in the company and faced this humongous amount of loss. And third, uh, anything else you want to give tribunal, give that also. What does it mean? First, restrain the company. Second, what did we say? Demand compensation or damages. And third, seek any other remedy as the tribunal might deem it. Now, when you are seeking these things, will the tribunal give it to you? No, 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 no. Tribunal will say, wait. First, before I accept, tell me, how many of you are there giving this application? We said, sir, we are 5% of the total shareholder. Oh, you are 5% of the total shareholders. Okay. So you are all saying, coming together and saying what? Company has done something wrong. Yes, sir. That's what we are saying. Okay. Where are the other 95%? Why they are not feeling company did something wrong with them? How come only you 5% are feeling company did something wrong? Tribunal says, I am not saying all of you are frauds. No. I'm not saying you are fraudsters. No. Tribunal is saying, I want to know what is the opinion of the others who have not come to file application. Number one. Number two, is the directors of the company alone who are involved over here, or there are other people also who are involved? Number three, what is your problem? Company has done something, that is your problem, or company was supposed to do something but company did not do it, that is your problem. So commission of an offense is a problem, or omission is your problem. Understood? What is your problem? So if your problem, if your problem is commission or omission, let us see if that action of the company can be ratified. If it is already committed, it might be ratified. Possible to ratify means what? Subsequent approval. Or is it possible to authorize it? Let's check it out. If either of the things are possible, it's a win-win situation. Let's do it. Yes or no? So that is one option tribunal says. So tribunal says, I will accept your application, but before I accept, let me see whether all these things are proper or no. And most importantly, whether you all are filing this application in good faith or just trying to spoil the name of the company. Because tribunal says, if I find out that you all are filing this application which is of a frivolous nature or vexatious nature, meaning not having any serious purpose, or you're trying to bring an action without a sufficient cause against the company, I have the power to not only reject your application but also ask you to pay a compensation of 1 lakh rupees to the company. Up to 1 lakh rupees of compensation I can order you to pay to the company, because you are spoiling the goodwill of the company, you are defaming the company. Yes or no? Apart from that, tribunal says, if I will accept your application, if everything is okay, I will accept it. But while accepting, first there will be a public notice which will be made, so that any individual cases pending at any other courts should be consolidated over here where the class action suit is filed. You cannot have multiple class action suits against the same company for the same reason at the same time. It does not make sense. So that cannot be done. Okay. So only one class action suit will be filed. Any independent cases are also there. Consolidate everything and bring it over here. Understood? Don't worry. Everyone can give in their applications over here. Whatever is the cost of application, legal expenses involved by you, common people, if it is proved that you are right, tribunal says, I will ask the company to defray the cost. I'll ask the company to defray the cost means what? Provide for that cost. Understood? So that also tribunal can order. And finally, tribunal will pass an order which will be final and binding on every. Final and binding meaning what? No appeal will be filed against the order of class action suit. Is that clear? Yes? Understood? Pretty quick, pretty fast. Class action suit on your screen. I hope you already have the notes. If not, just take down the notes, screenshots, or do the markings over here. I'll keep on scrolling, and then we'll go on to the new chapter super fast. Done? Shall we? Okay. All right. Now let's go on to something new, something different. What new chapter are we willing to do now? One more chapter we want to revise, right? One more chapter at least we want to revise right now. Actually, more than one we want to revise. So, what shall we revise? What shall we revise? Shall we shift a little bit to the other laws portion? Too much of company law we have been doing, right? Too much of company law we have been doing. Let's shift to other laws. In other laws, which chapter are we planning to do? Let's talk about, shall we talk about arbitration conciliation or FCRA? Yes? Sure. Okay. Technically, I know right now I'm talking to myself only, but I am assuming you are all listening to and nodding your heads and responding to me. So let's go on to Arbitration Conciliation Act first. Okay. And then we'll go on to FCRA. Okay. Now, when I talk about Arbitration Conciliation Act, you don't need to look at the screen for some time. All you need to do is properly, thoroughly listen to me. Every word that I speak, please listen to that very properly. And then we'll go on to the screen and I'll show you whatever you have to compulsorily read from this chapter. Okay. Let's go to Arbitration and Conciliation Act now. Arbitration and Conciliation Act. No need for screen, just listen to me very properly. So when we talk about this Arbitration and Conciliation Act, what is it that you need to understand first? Okay, see, disputes can arise. Lot different types of disputes can be there. We need to first bifurcate whether it's a civil dispute or a criminal dispute. If it's a criminal dispute, then it has to go to the court only. It cannot be resolved through arbitration. Apart from that, if it's a civil dispute, then there are different methods for overcoming or resolving your disputes. We call them alternative dispute resolution mechanisms. What do we call them? Alternative dispute resolution mechanisms. For example, you can resolve your disputes through arbitration. You can resolve your disputes through negotiation. You can resolve your disputes through mediation. You can resolve your disputes through conciliation. You can also resolve your disputes through litigation. Litigation means filing a case in the court of law. Understood? Sir, which one is better? Arbitration is better or litigation is better? Well, I'll tell you. If it's not a criminal dispute, it should be resolved by arbitration. It is always better to resolve your dispute through arbitration. Why so? Why is it better through arbitration? Let me tell you. In arbitration, what happens is the first and the most important benefit that you will get is in case of arbitration, when you resolve your disputes, you will get the benefit of confidentiality. Yes. Whereas if your dispute is resolved with the order of the court, if your dispute is resolved with the order of the court, in that case, there is no confidentiality. Am I right? There is absolutely no confidentiality there. Whatever is the order of the court, it will be published immediately. You will be all over the press, right? So order of the court will come in case of litigation. Here you will get benefit of confidentiality. Now I am a working person. Yes. And there is a dispute that we are having with someone. We want to resolve the dispute, but when the court summons, I cannot tell the court, it's a working day. I will not get a leave on this day. I cannot come. Can we have a court hearing scheduled at 8 o'clock, 9 o'clock, 10 o'clock in the night? Possible? No. But in case of arbitration, you will have that liberty. Flexibility of time, flexibility of place. Yes. Flexibility to select your own arbitrator also. Imagine. In the court, if your case is there, can you tell the court, I don't like this judge, change the judge? Possible? No. But in case of arbitration, you can have your own arbitrator. You can have your own arbitrators. You can select more than one also. 1, 3, 5, 9, 11, 12, 13, not 12. So why not 12? Because As I said, 1, 3, 5, 7, 9. It has to be in odd numbers. Understood? So that the decision always comes with the majority. Now, when we talk about so many things over here, understand, in the court, one benefit is there, that if you are not satisfied with the order of the court, you always have the option to file an appeal to the higher court. But this option is very, very restricted under arbitration. In arbitration, if you want to file an appeal, it will never be so easy. Why I will tell you it will never be so easy? Because in arbitration, now, first of all, whenever the order of the arbitrator is passed, it is passed with the consent. It is passed with the consent of both the parties. Understood? So when the order is already been given with the consent of both parties, why will you file an appeal against the order which is given with your consent? So it doesn't make any sense. You will have to prove that the order was passed without your consent, or the arbitrator was biased, arbitrator was partial. You prove that, then only you might be allowed to challenge the order of arbitrator. Otherwise, no. So how to study this chapter? I will show you the notes also. Before I show you the notes, I'll just clear some concepts. Okay. When we see the notes, you will come to know when you are actually reading, when you are actually studying this chapter now, guys, you need to remember one very important thing. And that is, while reading the answers of this chapter, you must make sure what? You must make sure that you by heart all the head points that I have given over here. Understood? Every answer, every concept has head points. You need to by heart those head points. If you by heart those head points properly, the inside matter, you can write it in your own words. There is no issue. There is no problem over there. Understood? But the head points should be perfect. There you cannot make a mistake. Understood? Okay. Arbitration. Now, see, disputes, as I said, they can be between any two persons. Now, when I say any two persons, means it can be disputes between two people like you and me, where you are also in India and I am also in India. Yes or no? It can be disputes between a person from India and a person outside India. It can be disputes between two people where both of them are from outside India. Possible. So what do we need to understand over here? Here we need to understand that, number one, if it is a dispute where at least one party is Indian, it is known as domestic arbitration. What is it known as? Domestic arbitration. But if it is a dispute where either of the parties is Indian and another is not an Indian party, in that case, it will be known as ICA, International Commercial Arbitration. What will it be known as? International Commercial Arbitration. Is that clear? Understood? So, at least both the parties are Indian, domestic arbitration. At least one party is a foreign party, it is international commercial arbitration. Sir, what if both the parties are foreign parties? Yeah, both the parties are foreign parties. What is that known as? How would I know? Two parties in their country, they are fighting. How would I know what is that known as? Right? So we only have two concepts, domestic arbitration and ICA, International Commercial Arbitration. Now, how will you appoint the arbitrators? Well, if you have your own reference to any arbitrators, you can suggest them and appoint them. Understood? They have to be appointed with the consent of both parties. Okay. But if you don't have any reference, what you can do is you can go to the court. Sir, but if I go to the court, it will become litigation, right? It will be litigation. We are not going for litigation over here. We are going for arbitration. How can I go to the court? I am saying, go to the court. Go to the court and tell the court that, sir, your honor, we want to resolve our dispute. We want to resolve our dispute, but we don't want you to help us to resolve our dispute through litigation. We want you to help us to appoint arbitrators so that we can resolve our dispute through arbitration. Understood? Now, which court shall I go to? See, if it is a case of international commercial arbitration, you will go to the Supreme Court. If it is a case of domestic arbitration, you will go to the High Court. Sir, so Supreme Court, High Court, they will appoint arbitrator? No. When you are going through international commercial arbitration, that is one party is a foreign party, you go to the Supreme Court, make an application to the Supreme Court. Supreme Court will appoint any particular High Court who will be responsible to help you to appoint arbitrators. And in case of domestic arbitration, wherever the dispute has arisen, you go to the High Court of that jurisdiction. Okay, either the High Court itself or it will appoint some district court who will appoint arbitrators for you. That way, your arbitrator will be appointed. There can be multiple also, there is no issue. Now, arbitrator is appointed. Now, what, sir? Once arbitrator is appointed, then what? Now, once arbitrator is appointed, you have to disclose everything to the arbitrator. You means who? Both the parties under dispute. Now, see, one interesting fact I will tell you. There is no condition that arbitrator should be Indian only. No. Nationality of the arbitrator is immaterial. Understood? Not only nationality, rather, if there is a dispute between two parties where one of them is a foreign party, it is given to them to decide. The power is to them, given to them to decide where and which country they want to resolve the arbitration with. They have a dispute. They want to resolve the dispute. But how to resolve the dispute? They have the freedom to decide that. They can decide that we want to resolve a dispute in India, or they can decide we want to resolve a dispute in a foreign country. Whichever country they will decide, the laws of that country they have to follow. Understood? The laws of that country only they have to follow. So here, whichever country they are deciding for the purpose of arbitration, it will be known as their selected seat of arbitration. And the laws of that particular country will apply, and they have to resolve their dispute with the help of the laws of that particular country only. Is that clear, everyone? Yes or no? That is what we call it. We call it as a seat of arbitration. Then comes finally, after listening to all the documents, explanations, information, everything about the parties, arbitrator will give his order. But this order is not an order. This order is an arbitral award. What is this order? This order is an arbitral award. We call it what? We call it as an arbitral award. Why do we call it as an arbitral award, my dear friend? Why do we call it as an arbitral award? We call it as an arbitral award and not an order because it is passed with the consent of both the parties. Understood? Whenever this order is passed by the arbitrator, understand this thing very clearly. Now, I had a dispute and arbitrator just passed an order in my case. So I asked the arbitrator, sir, how did you pass this order? What made you say these things? Whatever order you have passed, how did you do that? You know what arbitrator told me? Arbitrator told me, after listening to both the parties, after verifying all the documents, I think, I feel, I feel that you are the culprit and you should be convicted and you should pay a compensation of 50,000 rupees to the other party. I said, sir, but how did you come to that amount of 50,000? How did you determine the valuation of the fine, of the penalty? That I feel, I think that much is appropriate. I think that is, law says, Arbitration Act says, we do not want to know what you think, Mr. Arbitrator. Your arbitral order, your arbitral award has to be passed on the basis of the provisions of any particular law or on the basis of the decided case laws which are applicable. Understood? After referring to the decided case laws or the provisions of any particular law only, your order will be passed. And that is only how you will give your order. Otherwise, no. Understood? And whatever order is given, it has to be in writing and there has to be, what do you call it? What do you call it, guys? You must have studied in foundation. There has to be a consensus ad idem. Consensus ad idem means what? Clarity of minds, mutual consent by all the parties, meeting of the minds should be there. Meaning, it should not be an award which is passed by the arbitrator without considering or without providing opportunity of being heard to either of the parties. No, that cannot be done. Is that clear? Now, if at all there is a dispute between you and me, and the dispute is with regards to violence, riots, yes or no? illegal transactions. These things cannot be resolved through arbitration. They are criminal offenses and they have to go for litigation only. Okay. So let me tell you something interesting. You know how many types of arbitration agreement can be there? How many types of arbitration agreements can be there? Any idea? I'll tell you. Mainly that we have to understand and we have to study. There are three types of arbitration agreement. One, the first one is known as arbitration clause agreement. The second one is known as the submission agreement. And the third one is known as arbitration agreement through reference. Okay, arbitration clause, submission, and arbitration agreement through reference. Now, what is this? Arbitration clause agreement or submission agreement or arbitration agreement through reference. What is it? Tell me. You all must have been going for doing some or the other shopping, right? Some or the other shopping you do. Now, when you go to do any shoppings, any kind of shopping you go to do, you know, even if you buy one piece of shirt or one piece of a trouser or even as something as small as batteries from a mall or from store like DMart, even for a small thing that you are purchasing, they'll give you a long invoice every time. And you feel, what a waste of paper. What a waste of paper. But actually what they are doing is they are not actually wasting the paper. They are making their side safe. If you read on that paper, if you turn the paper behind and if you read, it is written that as you are accepting this invoice, you agree that if there is any dispute with regards to the product that you have purchased, you will resolve the matter only through arbitration and the arbitrator will be of the jurisdiction of this state where the store is located. Getting my point? So if I come to Kerala, I do some shopping over there, I buy a shirt from there and I come back over here and I found out that the shirt is torn from 4 places. I want to file a case against them. I cannot file. Why? Because while purchasing the shirt, I accepted that invoice. And if I accepted that invoice, I accepted the fact that arbitration clause is mentioned over there, which says that I will resolve the matter through arbitration only. Number one. Number two is your submission agreement. What is submission agreement? Submission agreement is there is a dispute that has arisen. But before the dispute arises, we did not decide at the time of entering into agreement that in case of dispute, how we will resolve the matter. How we will resolve the matter, we had not discussed or decided that. Understood? So what to do now? So now dispute has arisen and now both the parties are coming together and deciding, so what to do? Should we go to the court? Should we file a case against each other? Yes? No? Shall we resolve the matter through arbitration? Yes or no? Agree? Agree? You agree? I agree? We both submitted to arbitration. Understood? And the third one is known as arbitration clause agreement. What is it known as? Arbitration. No, sorry. Third one is known as arbitration agreement through reference. Now, what is arbitration agreement through reference? So what happened over here? When we entered into an agreement for doing any transaction, we decided that if there is any dispute between us, we will resolve our dispute through a particular notification or a particular book or a particular set of rules and regulations only. Okay, we will resolve our dispute through this set of rules and regulations. Okay, now dispute has arisen. When the dispute arises, we said, okay, so we want to resolve the dispute now. I said, yes. So how to resolve the dispute? We will resolve the dispute through the set of rules and regulations. Okay, so fine. How to resolve the dispute? Set of rules and regulations. Open that set of rules and regulations. When I opened, it was written over there, these type of disputes shall be resolved through arbitration. So what did I do? We are solving our matter through arbitration. But how did we decide that we want to resolve the matter through arbitration? We decided it through a reference to a particular set of rules or regulations, a book, or any particular thing. A very famous case with respect to this arbitration agreement through reference is given in your study material also, is given in your question bank also, given my question bank also, given everywhere. It's a very famous case. Yes, sir. The case is Group Chimic Tunisian SA versus Southern Petrochemicals Limited. I repeat, Group Chimic Tunisian SA versus Southern Petrochemicals Limited. Understood? So refer to the case. It's a brilliant case, and you will understand the arbitration agreement through reference concept from there. Is that clear? So what is that? That is your one more type of arbitration agreement. What next in the arbitration chapter? Let's see that. So what is arbitral tribunal? Arbitral tribunal means what? See, I'll tell you. Arbitration is one of the methods for dispute resolution, just like litigation. For litigation, you have courts. Like that, for arbitration, you have arbitral tribunal. Understood? In arbitral tribunal, you will find a panel of arbitrators. Who are arbitrators? They are, as you know by now, they are the people who act like the judges of the court. Yes or no? And they help you to resolve your problems. Is that clear? Only difference that you can understand between litigation and arbitration or arbitral tribunal will be here. You will get a choice. You will get a choice to select a panel of your arbitrators. You can have 1, 3, 5, 9, as I told you. It is up to you. Let me tell you, it's not free of cost. You have to pay the fees for them. All right. So for those services, you have to pay the fees, but otherwise, you can get an expert evaluation of your dispute from them, because they will be giving you the verdict or their opinion by referring to the case laws or maybe certain provisions of any law. Understood? But it is an entire process of arbitration which is held by them, which is done in cooperation with all the parties who are there under dispute. So moreover, you can say the success of entire process of arbitration depends on how the parties cooperate with the arbitrator and how the arbitrator exercises his skills, his due diligence, his the time, yes or no, for the purpose of giving the verdict. Is that clear? That is how your arbitrator will come into picture. Now, what are the requirements for appointing an arbitrator? As I told you, no nationality compulsory, no nationality. Only requirement is he should be not a minor, of course. Yes or no? Should be capable of contracting. Should be capable of contracting means what? Should not be an interested party or related party to any of the parties. And most importantly, there should not be a question on his character or integrity, meaning there should be a lack of bias. In that case, you can appoint any person as an arbitrator. Sir, but arbitration, overall, how does it help me? Apart from whatever litigation, arbitration differences we understood, what is the other benefit that we can have because of arbitration? Well, let me tell you one most important benefit. One most important benefit that you will have because of arbitration will be less time, quick result. That is conducting the proceedings without a delay. It is one of the, you can say, duties of the arbitrator to make sure that the arbitration proceedings are conducted smoothly and without causing any kind of a delay in the process. In the courts, we don't have a control. Maybe 1 month, maybe 2 months, maybe 6 months, maybe 2 years, maybe 5 years. The proceedings may keep on going, but in case of arbitration, that won't happen. That won't happen. In case of arbitration, the main advantage is the proceedings are conducted without delay. But having said that, also keep a note of conducting proceedings without delay does not mean conduct the proceedings so fast that you pass your verdict or you give your opinion without listening or giving equal opportunities to both the parties. Only thing you have to remember is there should be a lack of bias, as I said. So no partiality, no partiality, no partiality at all. Because even after appointment of arbitrator, if I feel that the arbitrator is being biased, the parties do have the authority to replace or remove the arbitrator. And confidentiality, of course, as I told you, is going to be one of the most important points. Next, you have to remember, it is one of the requirements or duties of the arbitrator that whenever any discussion happens, arbitrator should make sure that both the parties are present. Understood? Arbitrator discussing any matter with the parties under dispute, both the parties have to be present, which means what? Unilateral communication should not be done by the arbitrator. Arbitrator cannot say like, party A, just wait outside, let me talk to party B. And then party B, you wait outside, let me talk to party. No, 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 no. Whatever is going on, everyone will sit together on the table and everybody will find the solution. Whatever documents, witnesses, evidences are provided by party A to the arbitrator, what arbitrator has to do is legally, lawfully provide everything to party B. Whatever is given from party B, arbitrator will give everything to party A. Understood? All the matters, everything will be exchanged between the parties with arbitrator present in between. And then after everyone has referred to all the documents, then they can start discussion on how to resolve the dispute in a very, very effective as well as an efficient manner. Remember, whatever is the solution suggested by the arbitrator, it has to be legal only. It has to be what? Legal only. Sir, once we appoint an arbitrator, should we keep the same person as arbitrator, or as you said, we can change the arbitrator or terminate the arbitration entirely? Yes or no? Answer is of course. Of course, you can terminate the process of arbitration also. You can terminate the arbitrator also. Yes. Sir, under what cases we can say that the arbitrator will be terminated, or what cases are there where the arbitrator will leave? See, first and upfront, I'll tell you the easiest one. Voluntarily. Arbitrator only says, I don't want to continue with this case. I'm going. Yes or no? Or where both the parties or all the parties who are there in this dispute, they all come together and mutually decide that we want to replace the arbitrator, we want to change the arbitrator. Or another option is if the arbitrator becomes biased towards any party, or arbitrator develops any kind of interest or relation towards any party, then as per the requirements of the law, you have to remove that arbitrator. Understood? And if all goes well and all ends well, in that case, when the entire process of arbitration ends, you have to remove the arbitrator, of course, because you are not going to take him home with you, right? So then the question is, sir, process is ended. Can I appeal against the order of arbitrator, or can I challenge the order of arbitrator? Well, logically, if I tell you, no. Of course not. I mean, of course. How can you even think about doing that, right? How can you even think about doing that? Because why am I saying that? As I said, arbitrator's verdict or arbitrator's opinion, we call it arbitral award, is going to be passed after the consent of both the parties. So if you have already given your consent and then the order has been passed, how can you file an appeal against such kind of an order? Does it make any sense? No, absolutely not. Am I right? And having said that, also remember, guys, if you can prove that arbitrator has passed an order or given an arbitral award, but you are not known about it, you don't know anything about it, or arbitrator was biased, arbitrator did not provide you an opportunity to present yourself or defend yourself, arbitrator has passed the award unilaterally by communicating with any one of the parties. Yes or no? Arbitrator has passed the award even after you did not give your consent. If you can prove this or any of this, you can definitely challenge the order of the arbitrator in the court. What court will do is, court will first forward the application to the arbitral tribunal itself to recheck, re-verify, and if required, revise the order. And then if it doesn't work out, the court will take the matters in its own hands, and then your arbitration will turn to litigation. Is that clear? Understood? Yes. So many things are there which we have been talking already. Let me just proceed once more, but this time quickly along with the notes in our hands. Okay. I hope you have downloaded the notes from the site that I gave you. And now let's proceed to the notes. Okay, guys. Arbitration Conciliation Act. Notes in front of you. All right. Very quickly, let's brush through it. Arbitration. As we said, you can see the highlighted portion, one of the alternate dispute resolution mechanisms. Most important for you is what? Sir, distinguish between arbitration and litigation. So arbitration, litigation takes place in court. Arbitration place is chosen by the parties. Litigation, procedure, civil procedure code. And here, flexibility, construct their own procedures, no problem. Very little privacy, arbitration, full privacy, because that is the most important point, confidentiality. Numerous appeals, lower court to higher court, higher court to higher court, higher court to higher court, till Supreme Court you can go. Here, challenge of the arbitral award on very limited grounds. Difficult to enforce, yes. Court, yes. Difficult to enforce judgment of one country to another country. But in case of arbitration, arbitral award, very easily can be put on between the different countries, because it is all decided between the parties itself. Okay, this is your answer of litigation arbitration. Make a note of this answer, mark it important as well. Done? Okay, next, courts. Talking about courts, two types of courts as we know. First is if it is the case of international commercial arbitration, and in that case only high court, only high court. But sir, you said Supreme Court. What I said, in case of international commercial arbitration, only high court will appoint the arbitral tribunal for you. But which high court will appoint? For that you will make an application to the Supreme Court. Okay, so that is one thing over here. No. Yeah, Swades, meaning two local parties having dispute, it's a domestic arbitration. Normal arbitrator will be appointed. If it is one party Indian and another party non-Indian, that is out foreign party, then it is a case of ICA, International Commercial Arbitration. And where both the parties are foreign, I have no idea what is it known. Is that clear? Process of arbitration very simple. Party A is there, party B is there. They will appoint, they have a dispute between them, so they will appoint an arbitrator or someone from arbitral tribunal, we call them, who will do the adjudication for them and pass an arbitral award. Okay. Next, what are the basic features of arbitration? What are the basic features? Basic features can be pass face or sap face. Okay. Keyword I have given over here. Basic features, you can brush through them very quickly. I've highlighted the important points. I'm not reading through to save some time. You can just read through them quickly. I'll scroll through them. If you have any questions, you can just post them to me directly. Seat of arbitration and all, I have already explained these points, so that is why I'm giving it to you. Seat of arbitration, remember, country whose laws you are going to follow. Usually there is no appeal. Rarely possible in case of partiality or independence issues or incapacity, or in case of invalid arbitration done, then only appeal can be filed. Otherwise, usually there is no appeal. Confidentiality, topmost answer, always required in arbitration. Enforcement, it is simple to enforce the arbitral award in foreign nations as compared to litigation, order of the court, very difficult. Then, what are the requirements for passing an arbitral award? Statutory decided case laws or statutory provisions of any law. Other requirements, it should be in writing. There should be consensus ad idem. You can see I've highlighted consensus ad idem. What does it mean? Meeting of the minds or mutual consent should be there. Or arbitration award cannot be forced on anybody. No. Not possible. Understood? Then define the legal relationship. It means what? Cases of murder, kidnapping, yes or no, violence, riots, or any such criminal cases cannot be taken for arbitration. Order will be final and binding normally, whatever is the order, and certain matters, as I told you, are non-arbitrable. They can be decided only by the court. Easy? Easy peasy. Go through them. Super fast. Then, what are the different types of arbitrations? One, if you remember, I just told you a while back, arbitration. One of them is arbitration agreement through reference. Yes or no? Case also I had told you, if you remember the case, very famous case, Group Chimic Tunisian SA. we call it, versus Southern Petrochemicals Industries Corporation Limited. First, if you want to understand this concept, listen to what I already explained to you. I hope you have understood there. Second, read the example first. And after you read the example, then you can go on to the answer above the example. Understood? Don't read the answer first. Read the example first. It will be easier for you. Termination of agreement of arbitration. How will the arbitration agreement get terminated? One, mutual consent. Both the parties agree. Let's terminate the contract. Like any contract, parties involved can jointly agree to put an end to any existing agreement. Termination of the principal contract. Termination of the principal contract means what? The purpose, the dispute because of which the dispute was there. We went for arbitration. That principal contract itself got terminated. So there is no more arbitration. Death of the parties. Whoa. Death of the parties. One of the parties is dead. Arbitration will get terminated, but shall be enforceable on legal representatives. Okay. And lastly, operation of law. If there comes a requirement of any law by which your matter becomes non-arbitrable, your arbitration comes to an end, you might have to compulsorily shift to litigation. Okay. You remember two more types I told you for arbitration. Total three types I told you. Three. One we already discussed, which is given over here, arbitration agreement through reference, and the other ones, if you remember, one was arbitration clause. I gave you a example of a shopping mall, and then was submission agreement, where at the time of entering into agreement we did not have any arrangement between us that in case of dispute how we will resolve, and now we have decided that now since there is a dispute, both the parties have mutually decided, let's resolve it through arbitration only. Arbitration tribunal, just a while back I explained the concept of arbitration tribunal to you. I'll highlight the words over here. Arbitration, alternate method of dispute resolution. Arbitrator, judge of the court. Unlike court, parties get to elect their arbitrator. In court, you cannot say, no, I don't like this judge, change the judge for me. Possible? Not possible. Arbitration does not mean simply expressing opinion. What does it require? Expert evaluation. Yes or no? Then arbitration process depends on cooperation of the parties. Then quality of arbitrator will not only determine quality of arbitration, but also the outcome of the arbitral awards. The qualified, the more experienced the arbitrators are, the more better will be the arbitral awards. How about number of arbitrators? Parties can appoint any number of arbitrators. There is no problem. Only condition is it should be an odd number so that order can be passed by majority. Clear? Then you have appointment of arbitrators. Appointment, how it will be done? Parties have a dispute. Yes, they can go for arbitrator. It will start. The parties have a dispute, but they don't have any arbitrators. Okay, fine. They will go to the court as per the law. In case of ICA, Supreme Court will appoint the High Court, who will appoint the arbitrator. In case of domestic or national, High Court will appoint it itself or appoint any other domestic court. Correct? See, this is party 1. Party 2 will have an arbitrator who will resolve the problem, or it can also be like if 3 arbitrators are there, party 1 has an arbitrator A who is representing the party 1, party 2 has arbitrator B who is representing the party 2, and then there is one common presiding arbitrator who will pass the order or arbitral award. What are the requirements? As we have already discussed, I told you in the beginning of this chapter, by heart the headings very properly. You can by heart the headings over here. You can see the headings and understand the answer. Requirements for arbitral tribunal, what? Arbitrator can be of any nationality, should be capable of contracting, and should be full of lack of bias. Yes, guys. So we are really working very hard over here so that you can score very great marks in your exams, guys. I hope you appreciate this efforts also. Yes. We don't ask for anything else. Just remember that someone out here is also praying for your success out there. Understood? I mean, of course, you are working very hard. So your hard work and our prayers and your parents' blessings, of course, and nobody can stop you. Let's go further. Duties and liabilities of the arbitrator. Have we talked about them already? Sir, what are the duties and liabilities? Let's check it out. Have we talked about them? Conducting the proceedings without delay. Something like that we have already talked about, right? Should be at all times impartial. Yes or no? Confidentiality, though, I don't remember now how many times I must have used the word impartial, lack of bias, confidentiality in this chapter. Yes or no? Every other answer that we are talking about has the word confidentiality and lack of bias. When something new is coming up, deliberation. What is it? The arbitral award or arbitral tribunal should properly discuss all the issues before issuing a decision or award. The award should be a reasoned award. In other words, arbitrators should discuss the matter with each other thoroughly and through majority render the award. Deliberation means what over here? It means whenever an arbitral award is passed, no, deliberated efforts shall be taken on the part of the arbitrator to make sure that both the parties in the dispute feel that okay, the judgment has been passed and the judgment passed is sound, the judgment passed is reasonable, and the judgment passed is the most practicable judgment. Understood? So for that purpose, deliberate efforts are required to be taken, but at that time, avoid unilateral communication with single parties. Whatever is received from one party, communicate with the other party. Share everything with each other, but share everything with no other. Understood? Your arbitral award should comply with legal requirements. Arbitrator cannot say, I feel it's your mistake. Jump from here. We are on the 10th floor. That cannot come under arbitrator. Comply with the legal requirements. At all times, comply with the legal requirements that are required or associated with arbitrator also. Understood? What? Whenever you are giving any order, you also disclose on what basis are you giving that order. What is the criteria that you have considered for passing such kind of order? Can we remove, terminate, or substitute the arbitrator? Of course, yes. We gave you examples also. Arbitrator himself is leaving voluntarily. He can be terminated. All the parties agree that arbitrator shall be removed. He can be terminated. Yes or no? Inside matter, guys, whatever is written, I have already explained it to you in the part before this when only I was there on the screen. I have already explained that to you. So that should not be a problem for you. Okay. Operation of law, arbitrator will be terminated. Example I had also given to you for operation of law where the matter does not remain arbitrable. For example, as per the law, it is treated as a criminal offense. Arbitrator will be removed and matter will go to litigation. When the arbitration process is over, arbitrator, you are not supposed to take him home. Arbitrator arbitration will terminate and arbitrator will leave. Or where the court decides. Court decides that new arbitrator should be appointed or old arbitrator shall be removed. Understood? Now then the question arises, sir, whenever any order is passed, already passed, can we challenge the order of the arbitrator? Yes, of course. As I said, if you remember, first it must be challenged to the arbitral tribunal itself. And thereafter, if you are still not satisfied, then after that, it can be challenged in front of the district court for a domestic arbitration, high court for international arbitration, but then it will turn into litigation. Okay. Once arbitration is over, then what? Then what? Then arbitrator will pass an award. That award will be a conclusive determination that whatever I have heard between both the parties, I am giving my opinion and I am rendering my award, which shall be acceptable to both of you. Ideally, yes, after giving a reasonable opportunity of representing themselves to all the parties involved. Okay. Some general principles I will take up with you, but before that, I need you to quickly, yes, from here, run through these points. Okay, I'll be keeping on scrolling. So either you can read them if you have the notes already with you, or you can take screenshots and read it later. Better than taking screenshots, I gave you the name of the site earlier also. You can get it from here under the free downloads section. Okay, so it is all for you. Whatever is possible, I'm giving it to you. I hope you will appreciate that, and I'm also praying for you. So here you are. Kindly take it down fast. Okay, perfect. Sound, sound okay. Set. All right. Let's go to the general principles, guys. These are some concepts which are important from your MCQ perspective. So let us see who can challenge an arbitral award. When there are two parties under the dispute, any of the parties only can challenge. Nobody else can challenge. Where will you challenge? Only be challenged before the court. Yes or no? Which court? We already discussed. Timeline for challenge 3 months plus 30 days will be the extension period which might be given to you in case of genuine reasons for not challenging within 3 months. Automatic stay means what? According to the act, there is no automatic stay on enforcement. What does it mean? Just because you have challenged the order of the arbitrator does not mean whatever was the arbitral award, there will be an automatic stay which will be imposed on that, and you don't have to comply with the arbitral award because you have filed an appeal. No, 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 no. Don't even think in that as that direction. Understood? Whatever is the order of the arbitrator, you have to comply with that, and you can challenge that award further. Understood? So there is no concept of automatic stay. What are the types of arbitral award, guys? There are 4 types of arbitral award, as I told you. First one is final award. Final award means what? Full and final, last award, which is given by the arbitrator considering the provisions of the laws. Then you have interim award. Interim award, there are two varieties. One is like a stay order. Okay. One is like a stay order. That is an order which is given in the middle of the arbitration proceedings, and then another order will be passed at the end of the arbitral proceedings. Another type of interim award is like an order of stay is passed, and so far as arbitral proceedings are concerned, if the order will be changed, it will be intimated to you. Otherwise, this order itself shall be treated as the final order. That is, it should be there till the end. So same order will continue. Understood? Again, interim order of two types. Two types. One is, where is it gone? One which remains in force till the final order. Once the final order will come, the previous order, that is the interim order, will be lapsed. And another is final as regards the matter, meaning right now I'm considering it as an interim order. Okay. And I'm passing the order and still listening to both the parties. So if there is a change of mind after listening to both parties, we will revise the order. Otherwise, this interim order itself shall be taken forward and treated like a final order. Then you have a settlement order. Settlement order means what? Both the parties have come together and decided that, okay, we will together agree and settle at a particular point, and we don't want to further adjudicate this matter with the arbitrator ahead. Additional award means what? Additional award means there were few matters in arbitration where most of them are resolved, a few of them are unaddressed. Okay, so final order was passed, but one or two or three matters were untouched during arbitration. So here, after the final order is passed, separate orders are being given for any left out matters. That orders will be known as additional orders. Now, these four types of orders are given over here. To understand them in a little bit more better way, we have given case scenarios over here. Understood? What have we done? We have given case scenarios over here. Okay, so you can go through these case scenarios. Case scenarios means what? Examples. Examples given for all of them, very easily to understand. Requirements for arbitral awards, simple. It should be given by majority. It should be signed, writing, and dated, and must be a reasoned award. Reasoned means what? If you ask the arbitrator, why did you pass this award? Arbitrator cannot say, I thought so. You thought so? Nobody cares what you thought. Reasoned means what laws, what provisions, what have you, case laws have you referred to for passing this order? State everything over here. And whatever order you are giving, it must not be vague order. Vague means what? Not sensible order. Asking you to do something which is insensible. Understood? Okay. Now, for these points also, we have given, see, case scenario 1, 2, and 3 over here. 3 different scenarios to explain. And then more points are there, like it should be capable of being performed. Bring the moon and bring the stars. Jump from the 10th floor. Not possible to be performed. So those orders are short, should not be given. And whatever order you are giving must not be illegal also. Like party A, it's your fault. Okay. Party B, slap him. Slap. It is against the public policy. Yes. Such a word shall not be passed. Is that clear? Very quickly go through the head points again. Let's have a sip. What are the other requirements with respect to arbitral awards? First, delivery. Whatever order you are passing, it has to be delivered. Without delivery of the order, what kind of an order are you passing? Challenging an award, it can only be done on specific grounds. And what are the grounds? What are the grounds? Now understand. They are saying there are 3 grounds. Okay. Are there really 3 grounds? No, sir. There are not 3 grounds. There are actually more than 3 grounds. But how are they explained over here? See, I will tell you. 3 grounds to challenge, they said, right? 3. So I'll put it like this: 1, 2, and 3. First ground, yes, you can challenge. Second ground, yes, you can challenge. Third ground is an option for not challenge, but request to review that award, in which we have review options divided in 2 parts. In the first part, you have 5 points. And in the second part, you have 2 points. Understood? See, here I have explained it over here. First point, you can challenge the award. They have given it how. Second also, award challenge. Third point talks about review, where in the first half, there are 5 points. It is divided in 2 segments. Segment 1 has 5 points where challenge or review request can be sent by the party, either of the party. And other 2 points where review request can be sent by the court, suo moto by the court itself. Understood? Let's have a quick look. First one, order is biased, you can challenge. I'm not even talking about it. Second one, overstepping of the jurisdiction. What do you mean by overstepping of the jurisdiction? Overstepping of the jurisdiction means where the arbitrator is appointed. Arbitrator has certain jurisdiction. Jurisdiction means certain powers over here, within which his boundaries are fixed and he cannot exercise any powers beyond his boundaries. But if the arbitrator is crossing his lines or crossing the boundaries, in that case, arbitral award can be challenged because arbitrator has crossed his jurisdiction crossed its boundaries, and passed an arbitral award. For reviewing an award, as I said, two options are there. First set of grounds include where the party himself wants to review. Five options are there. First one being party is under some incapacity. Party is under some maybe contractual incapacity, maybe personal incapacity, and that is why party wants to review. Okay, fine. Arbitration agreement itself is invalid. It cannot go only for arbitration. I don't know how arbitrator has passed the order or is even undertaking the arbitration. So I want to review and check whether it is arbitrable or not. Party has not given proper notice about appointment of arbitrator or arbitral proceedings. I am one of the parties. About the arbitral proceedings being going on or about appointment of arbitrator, I have not properly intimated to the other party. Understood? In that case, other party can definitely review. Award deals with disputes which are not submitted to arbitration. We are going for a dispute, for example, with the arbitrator that we both are husband and wife, and we have a dispute. And arbitrator, please help us to resolve the dispute. And arbitrator says the custody of the child will be with his mother. Arey, that is not our dispute. We don't want to get divorced. We are just saying there is a dispute and we want you to resolve a dispute. What is the arbitrator doing? Dealing with the matters which are not even submitted for arbitration. Understood? And fifth one, arbitral tribunal or the procedure was not in accordance with the requirements of the law. So entire arbitration procedure was not conducted in the best possible. See, example I've given you, treating both the parties equally. Where you don't treat both the parties equally, you are not complying with the law. Understood? So here, yes, here also order can be reviewed. Another two options are where the court can look into the matter on its own motion. On its own motion means suo moto. Understood? Where first one, court feels arbitrator, you have taken this matter for arbitration, but the matter no longer looks arbitrable. The court will take over. Or court feels the order given by the arbitrator is against the public policy of India, like slap somebody, jump from the 10th floor. Yes or no? Take revenge. No. Consequences, what if the arbitral award is challenged? One, it can be set aside. Set aside means cancelled. Second, it can be confirmed. Confirm means what? Whatever is said by the arbitrator, that is perfect, and we don't want to change the award of the arbitrator. Third, modify. Modify means what? Whatever award is given by the arbitrator, well, more or less it is correct. Few points we can change it. So the court will order for changing or modifying the award where of certain points of the award may be modified, rest everything remaining same. And last, remitted back to the arbitral tribunal. Court says, I don't want to take this case for litigation. It's a very small case, very petty case. It's a case of question of facts and not of question of law. So I am giving my recommendations and giving it to the arbitral tribunal to pass a revised arbitral award by arbitrator himself. Understood? These are the consequences that can happen if you challenge the award of the arbitrator. Is that clear? Yes or no? Sure? Okay. Now, in conciliation, I'll just take this distinguished for you because it's an important one. What is conciliation? Again, one of the dispute resolution mechanisms, right? So, what is the difference between, sir, mediation and conciliation? Let me tell you. What is the difference between mediation and conciliation? Let me tell you. Mediation will have a mediator. Conciliation will have a conciliator. Yes or no? This is not a big point. Point is, in case of mediation, the mediator plays a facilitative role. Means what? I have a property and I want to sell it for 100 rupees. You are the buyer. You want to buy it for 80 rupees. If we have a mediator in between, mediator will play a facilitative role. Facilitative means he will introduce you to me, introduce me to you, and ask us to talk to each other and see if we can come to a settlement. Understood? If no, he will say, okay, party want to purchase, we'll find some another party for you who is ready to give you the property at 80, and he will tell me, I'll find some another buyer who is ready to purchase at 100 rupees from you. Conciliation, your conciliator will play a proactive role. These words will come for MCQs. Proactive role, acts as a facilitator, acts as an intervener, acts as an evaluator. What does it mean? What is he actually going to do? He will come up with his own solutions to resolve the dispute. Understood? I want to sell it for 100. You want to buy it for 80. Conciliator will come in between and say, see guys, settle for 90. It is good for all. Understood? So the outcome will be the agreement between the parties. But in case of conciliation, we call it as a settlement agreement. Understood? Here, in case of mediation, whatever agreement is reached, it is a contract which is enforceable at law. You don't know what is a contract enforceable at law. Yes? But here, it will be treated just like an arbitral award. And it has to be implemented just like a decree. Decree means award or order of a civil court. Okay. Governed by CPC, that is Civil Procedures Code, governed by Arbitration and Conciliation Act. Confidentiality will be both the places common point. If agreement is breached, it is considered as breach of a contract. So Contract Act provision for breach of contract will become applicable. Here, it is enforced as an arbitral award. So if agreement is breached under conciliation, it will be as good as or treated as it is a breach of an arbitral award itself. Is that clear? Yes or no? This is the basic distinguish between that. You have to understand 4 to 5 marks of question you can expect from here on this distinguish itself. Okay, take this up, note this, note or highlight the points if you have it in your hands. Okay, or screenshots if possible, and then we'll go further to a new chapter. All right, let's go on to a new chapter. New chapter, and we are going to start with, let's do one of the very, very interesting chapters, that is insolvency and bankruptcy code, and then we'll go to FCRA also. Okay, now what is insolvency and bankruptcy code, my dear friends? Okay, this chapter, technically, when I take it in the class, of course, it is a chapter which takes me around 8 to 10 hours minimum to finish the chapter. Approximately 8 to 10 hours is what we require. If it's a class which I take in with logic itself in Kochi, where we have 9 to 5 lectures in every day, this is one particular chapter where I need one entire day non-stop. Then only we can finish this chapter effectively and efficiently. So it's a big chapter. I'll try to cover up as much as I can, but make sure now when you are listening to these concepts that I'm taking up with you, just make sure you have full focus with me. Okay, you have full focus with me. Like, please, honestly speaking, don't do anything else if you want to understand the concept of this chapter like pitch perfect. Okay, I won't be able to touch each and every area of this chapter, but I will definitely touch upon the major portions or the major areas of this chapter, and I'll brush through the notes also, covering those sections which I'm talking about right now, so that it will be easier for you to revise later on. Okay, just make sure you have the notes with you, but make sure you don't open them or don't search for the words or the points or the concepts that I'm talking about over here. Full focus just with me. All right, and trust me, you will understand this chapter like never before. Okay, let's talk about insolvency and bankruptcy code. See, first of all, when you talk about insolvency bankruptcy code, okay, apart from the basic introduction, let me tell you, in this chapter, what we have to study. When you are studying this chapter, no, you have to study 4 basic points. Okay, 4 things you have to study. Section 1 to section 59 is applicable from this chapter, that I hope you are aware. Now, what is given in 1 to 59? Okay, 4 standard things that we have to study. Pay attention. There is a company, and this company's financial position is horrible. This company's financial position is worse or maybe bad than the worst also. Now, when we talk about this company over here, or when we talk about its financial position over here, company might shut down. Sir, if the company might shut down, we might go to winding up. That is under Companies Act. Yes or no? Of course, yes. Of course, yes. But here, there comes the insolvency and bankruptcy code, which is your one more option available with you if you want to do the winding up proceedings as per IBC, but not as per the Companies Act. How it will happen as per IBC? What is the difference? Like why one person will focus or try to do it under IBC, or what is IBC? So as I said, there are four important aspects of IBC. First one is known as CIRP. Once again, sir, CIRP. What is CIRP? CIRP means Corporate Insolvency Resolution Process. Once again, repeat, Corporate Insolvency Resolution Process. What is Corporate Insolvency Resolution Process? So there's a company. The company's financial position is very bad. Company means a corporate is there whose financial position is very, very bad. Very bad as in the assets are way less than the liabilities. Liabilities are more than the assets. Okay. So meaning the company is about to become insolvent, about to declare insolvency, right? Yes, sir. Okay. But we want to save the company from declaring insolvency like we just did with Jet Airways. We want to save the company from declaring insolvency, bankruptcy. We don't want them to declare it. So what do? We give them first chance to save themselves under CIRP. Corporate insolvency, corporate insolvency is a problem. We want to resolve it. So corporate insolvency resolution. How to resolve it? For that, this process we are going to study known as corporate insolvency resolution process. That is the part 1 that we study. If the CIRP will fail, company will get into liquidation straight up. So we have nothing to bother or discuss or get confused about over there. If CIRP fails, company goes to liquidation. End of discussion. Easy? Okay, sir. Now, as we are talking about CIRP over here, what is it about CIRP that we need to understand? Or liquidation. Chalo, let me first, introduce all the 4 aspects. First is CIRP done. CIRP fails, we go to liquidation. Now, what if I am an MSME, okay, micro, small, medium enterprise? In that case, we have one more option, new option in the syllabus known as PPIRP. New as in, of course, it is not new as new. It is more than 1 year old, but we call it PPIRP, pre-packaged insolvency resolution process, PPIRP. Okay. And then the fourth one is your other miscellaneous provisions, in which we will talk about introduction to this chapter, characteristics of insolvency bankruptcy code, what are the new features of insolvency bankruptcy code, what is the concept of fast track insolvency, what is the concept of voluntary liquidation under insolvency bankruptcy code. So all those procedures will come under last miscellaneous points. Okay, so 3 top headings: CIRP, PPIRP, and liquidation. If CIRP fails, you go to liquidation. If PPIRP fails, you go to liquidation. Liquidation process will be same for both. Okay, in which case we can go for CIRP, in which case we have to go for PPIRP, which case we can go for CIRP, which cases we can go for PPIRP. Let's have it all in front of us and discuss it together. Okay, now what is CIRP? So there is a company whose financial position is very, very bad. So there are 3 types of people who might feel that we want to resolve the problem of insolvency of this company. Question is, who are these 3 people? Do you know them? Who are these 3 people? Person number 1 can be the company itself. The company itself feels that we are in a mess and we want to resolve this problem of insolvency. How do we resolve this problem of insolvency? Let's go for CIRP. Person number 2 and 3 are your creditors. So 2 and 3 are meaning 2 creditors are there? Yes. It is not 2 creditors, it is 2 types of creditors. Type number 1, we call them as financial creditors, and type number 2, we call them as operational creditors. What is a financial and what is operational creditor? It is given in the notes. I'm not getting into that detail. That's a 15-minute separate theory now. Okay. So financial creditors and operational creditors. Any of them, either financial creditor or operational creditor, if they are the creditors, then company for them will be the debtor, right? So company will be the debtor. So we call it a corporate debtor. Financial creditor, operational creditor, or the company, that is the corporate debtor itself. What they will do? They will go and file an application to the adjudicating authority. Now, when I use the word adjudicating authority, what you must do, always remember, for us CA final students, when we talk about paper number 4, CA final students, when we talk about paper number 4, adjudicating authority under IBC will always mean NCLT only. Okay. If you are not satisfied with that order, you will go to NCLAT, Appellate Tribunal. Understood? NCLT, NCLAT, and then you have Supreme Court, of course. But coming back. Now, sir, I am talking about normal process of a company. Operational creditor, financial creditor, or corporate debtor has filed an application to NCLT. What NCLT will do? NCLT will check their application. First, NCLT will ask them, what is the problem? Okay, what is the problem? How much do you think are you in debt? And what is the capacity of repayments? How much assets are there with the company? Now, what they will have to do is, for this purpose, NCLT says we have to do the valuation of all your assets. For the purpose of valuation, we need to appoint a person. The person who will do the valuation. Okay. This person is known as IP, Insolvency Professional. What is he known as? Insolvency Professional. But mind you, sir, right now we are not talking about insolvency. Are we? No, sir. Right now we are talking about how can we resolve this problem of insolvency. Okay. So right now you are talking about how can we resolve the problem of insolvency. Then I will not call him insolvency professional right now. Let's change his name, and instead of IP, let's call him RP. RP means resolution professional. Okay. Person may be the same. Only his name will change considering the time at which he is appointed. If he is appointed at the time of liquidation, we'll call him insolvency professional. If he is appointed at the time of CIRP, we'll call him resolution professional. Now, this company itself who made an application, or the financial or operational creditor who made an application to tribunal, they are saying, so, sir, tribunal. We know one resolution professional. We know one resolution. Tribunal, can we appoint our known person as a resolution professional? Tribunal says, why not? If that person is qualified, if that person is eligible, if that person does not have any disciplinary proceedings going on against himself, you can definitely appoint such person. But the condition is, when you are appointing this person, no, other people, other members of the company, or not members, I would say, but other creditors of the company should agree. Why? Because when you are actually appointing this person, no, you are appointing because you know this person. Other people of the company do not know this person. Okay. So make sure this person introduces himself to other creditors of the company, and then make sure that creditors approve his appointment. Minimum 66%. How much? 66% approval is required. Is that clear? Okay, sir. Okay. 66%, as you say, minimum 66% approval is required. Okay. Let's call this resolution but no, he is not a resolution professional. No, 66% has not given approval till now. Okay. I just recommended the name of this person, but he's not become a resolution professional on my own recommendation. I might be company, any financial creditor or operational creditor. Okay. So call him and tell this person, we are appointing you as a resolution professional, but you are not confirmed. You are not confirmed. Sir, not confirmed meaning you are temporary right now. Temporary meaning you are an interim resolution professional. So we will call you an IRP at this stage. You are what? Interim resolution professional. Okay, IRP. As an interim resolution professional, when you are coming, what is the first job that you are going to do? As an interim resolution professional, when you will come to the company, the first job you will do is suspend the management of the company. Board of directors, KMPs, management, everybody out. They will be like, no, we are here to help you in any way we can. We want to save the company. IRP will tell them, if you know how to save the company, then what am I doing over here? So apparently you have miserably failed to save the company. And that is the reason I am here. So please, you are all suspended. So, okay, our shareholders will appoint new director. No. Shareholders also stay at your home. Okay. No powers to the shareholders. No resolutions will be passed by shareholders. Nothing doing over here. There is a shift of control from the shareholders to the creditors. Meaning what I will do? Management out. Creditors coming. All creditors coming. After all the creditors are standing in front of me, I will bifurcate them. Operational creditor this side. Financial creditors this side. All of them bifurcated. Okay. Operational creditors. Please go back. We have our financial creditors over here, like bankers are there, PFIs are there. Yes or no? Qualified professionals are there. Financial creditors, all of you coming together, we are forming one committee. This committee will be known as the Committee of Creditors, which will comprise of all my financial creditors. But if the company does not have any financial creditor, or if all the financial creditors are related parties, well, in that case, the top 18 operational creditors will be appointed as a part of the Committee of Creditors, with one representative of employees and one representative of the workmen. Okay, sir, but 18 are not there only. We have total 15 operational creditors only. Then all the 15. If there are more than 18, then top 18 will be appointed. Is that clear? Everybody sure? Any doubts over here? Okay. Now, Committee of Creditors is ready. Now what I will do, I will introduce myself to the Committee of Creditors, saying that, my dear Committee of Creditors, I am your interim resolution professional appointed by any of the financial creditor or operational creditor or corporate debtor. Whoever appointed me, I will say that. My qualification, my experience, I will lay it down in front of them, and how am I planning to help them to save the company and recover their money, I will give them a brief. If they are satisfied, then I will continue. And my name will change from IRP to RP, because now they have confirmed with 66% majority that I should continue. Or if they are not satisfied with same 66% majority, they will remove me and appoint somebody else. Okay. Until and unless the new person is appointed, I will continue. I will not leave in between. Whenever a new resolution professional will be appointed, I will hand over everything to that person and go. But why, sir? If they don't want you, you go. No, that's not how it works. We are in a professional environment right now. And the moment tribunal accepted their application for doing the CIRP, their meter for calculation of 180 days has already started. You know what is this 180 days? This 180 days is a period within which they have to make the resolution plan. Maximum how much days they will get? Maximum 180 days. In this 180 days, they have to make their resolution plan. Understood? Once the resolution plan is ready, they have to submit it to the Committee of Creditors, approve it, and then to the tribunal for approval. For genuine reasons, from 180 days, you will get more extension up to 90 days. So 180 plus 90 is the standard, the maximum time that you can get. Apart from that, 180 plus 90, apart from that, if I tell you, during this process, during this period, the moratorium, it happens that the company has filed cases on different people for recovery of money. So if the company has filed cases on different people for the recovery of money, okay, then the court proceedings and all will take time. Correct. For that purpose, we are saying, okay, total, not more than 330 days. So how we are saying it? Moratorium period will be of maximum 180 days, plus for genuine reason, extension of 90 days will be given. Okay. But total 180 plus 90 plus 60. That is total will not be more than 330. That 60 extra which we are giving over here is for what? That is for any legal compliances or legal cases are filed. So for that time lapse that you have got, maximum 60 days you will get. But remember, having said that, also note that during this moratorium period, nobody will be allowed to file a case against the company during that time. No. That is the time where we want to save the company, not increase the pressure or increase the problems for the company. So during moratorium, nothing. So if the question comes you, sir, what is a moratorium period or how much is the moratorium period? You will write what? Maximum 180 days plus 90 days subject to total maximum 330 days? No. No. You know what? Write it like that. You will write it as moratorium period will be from the date of admission of the application by tribunal, when tribunal accepted your application, from the date of admission of application by tribunal up to up to up to the date of submission of resolution plan. Once plan is ready, plan is submitted, moratorium is officially over. Is that clear? Everybody? Yes or no? So now, chalo, okay. Moratorium 180 days plus 90 subject to maximum 330. We understood, sir. So that is the period within which we have to make the resolution plan. Okay. This resolution plan which we are making, it also has to be approved by same 66% majority. See, I will tell you percentage over here. Everywhere you will find 66% specifically given under IBC. Okay. For entire CIRP liquidation, everywhere you will find 66% is given. Second thing, if any resolution plan, or forget the resolution plan, if the application is given, that CIRP should start and resolution professional is appointed and discussion is going on, and then if the financial creditors, that is the committee of creditors, feel there is no point in saving this company, let's wind up the company and recover our money. Let's wind up the company and recover our, if the committee of creditors feel that, no, then they can withdraw the application also. Withdraw the CIRP application also. For that withdrawal, you will need 90% votes. 90. Apart from that, wherever specified, everywhere 66%. And in case under IBC, the CIRP liquidation process, if you find any point where nothing is given, then you will go with 51% or more. If you find anything, then 51% or more. Otherwise, 66 is given everywhere. Okay. So that is what your moratorium period. During this moratorium period, no transferability of shares, no filing of any legal cases against the company, no other authorities can come to the company for the recovery of money. Nothing can be done. Company can do whatever it wants. Yes, because you have to save the company. So company can do whatever it wants, but nobody else can bother the company. Is that clear? So what I will do? I will be, after being appointed as the interim resolution professional, within 3 days, I'll make a public announcement, call all the creditors, operational separate, financial separate, make a committee of creditors with all my financial creditors. Once they confirm that I am okay for them, I will become their resolution professional. Which professional? Resolution, not interim resolution professional, resolution professional. Is that clear? Now we will make the resolution plan. Whenever required, as many times required, we may convene the meetings of the COC, that is Committee of Creditors, of course. If Committee of Creditors want to call for a meeting of the COC, they have to inform the resolution professional with minimum 33% votes over here. 33% of the votes, they should inform the, get the approval and tell the RP that we want to call for a meeting of the COC, and we can call for a meeting of the COC. Is that clear? Quorum for this meeting also same, 33% should be present quorum. You can be present physically, you can be present by audiovisual means, but do not mix it with Companies Act and write 1/3. No, it's not 1/3. 1/3 is 33.33%. This is specifically given 33%. Okay. So what if quorum is not present? Quorum not present, meeting adjourned. Companies Act, remember, adjourned up to next week, same day, same time, same. Next week, same day, same time, same place. Here, it will not be adjourned to next week, same day, same time, same. No. Here, it will be adjourned up to next day. Next day, same time, same place. Only 180 days are there. How can you delay it for 1 week? You don't have that much of time. Yes or no? Of course. So, in the adjourned meeting also, if quorum is not present, then whatever is present, that is the quorum. Saving the company is more important. Make the plan, save the company. Is that clear? Yes or no? Okay. So now RP is there. Okay. Initially what happened? IRP came, he introduced himself, 66% votes, either was confirmed or was replaced, and RP came in. Okay. RP making the resolution plan along with the committee of creditors present. Whatever information, explanation, documents, records, vouchers, anything is required, management is suspended. But employees, officers are there in the company. They have to give full cooperation to the RP. Whatever is required should be provided to the RP. Whatever is required by the COC for taking any decision, RP should make sure within 7 days everything is provided to the COC as per their demands. Is that clear, everybody? Yes or no? If during this process the COC feels RP is not working efficiently, 66% votes, you can replace the RP also. Anytime, whenever you want. Until the new RP will come, I will continue. Okay, that is always going to be the same. That will never change. Is that clear enough? Yes or no? Whatever is required during this period, you can do to save the company. Okay. Now, let me take you to another important concept. So, let's assume resolution plan is ready. Okay. Within this period, resolution plan is ready. Now what? Now, resolution plan is ready. So, submit it to the COC first. Let the COC get it approved with 66% majority. If COC approves, perfect, job done. If COC does not approve, then no more chances, go for liquidation. If COC approves, perfect, go to the tribunal, give the plan to the tribunal. Tribunal also approves, start the implementation of the plan. Tribunal rejects, go for liquidation. Understood? Easy? This is where your process of liquidation will start and CIRP will end. Okay, simple overview. Overview is clear this much? Okay, let's go further. What about liquidation? Sir, when will liquidation start, or when will the liquidation be triggered under IBC? How or when will this liquidation get triggered? See, I will tell you. As we talk about liquidation, no? First of all, your 180 days plus 90 plus that 60 extra which I give, everything is over. No plan is presented. Liquidation will get triggered. Plan was presented, COC rejected. Liquidation will get triggered. Plan was presented, COC accepted, tribunal rejected. Liquidation will get triggered. Plan was presented, COC accepted, tribunal accepted, implementation started. During implementation, terms, conditions of the plan were violated. Liquidation will be triggered. These are what? Few cases where liquidation will be triggered. And now if liquidation triggers, my name will change from the RP to IP. IP, insolvency professional. My name will change from what? RP to IP, insolvency professional. Yes or no? You don't want me to continue? 66% votes and replace the RP. 66% votes and replace the RP. Understood? You can appoint a new person as the IP. No problem. What will the IP do? IP will now send a public notice and call all the creditors. Everybody come. No operational, no financial, finish, company shutting down. Now everybody come and come with your claims. Come with supporting documents for your claims and submit your claims. Operational also come, financial, everybody give your claims. What he will do? He will do the verification of the claims. Verify the claims, tally all the claims with the system, company system, and check whether those claims are legitimate or not. If they are legitimate, in that case, if they are legitimate, one second. Yeah. If they are legitimate, what he will do? He will accept the claims. If he feels something is fishy, he will reject the claims. If he feels supporting documents are given, but they are only for some portion of the claim, he might partially accept the claims. So when the claims are accepted, maybe partially, or rejected, the creditors have the option to file a case. Yes. Creditors can file a case against the IP. Yes or no? That can be done. Now, what IP will do? Verify all the claims. At the same time, do the valuation of the liquidation estate. What is valuation of liquidation estate? Whatever are the total assets of the company, belonging to the company, ownership of the company, everything will be valued. Understood? And then settlement of the claims will start. How the settlement will start, I will tell you. But settlement will start. All the assets will be disposed of. Money will be recovered. Payments will be done. Yes or no? Liabilities will be repaid. And the company will be declared as dissolved. Understood? That is the end of the company under liquidation. Wait. How the settlement of the claims will be done? That is very important over here. That is given under your section 53, I guess 53, 54. We call it as a waterfall model. I'll bring it up for you. No, I'll bring it up on the screen. After, I think, after 5 minutes. First, let me explain it to you. The waterfall model, how does it work? Okay. Then I'll bring it up for you. Here is the waterfall model. Yes, here it comes, the waterfall model. Okay, 53. Section 53 talks about the waterfall model. Now understand this very carefully. Why do we go under IBC and we don't go under Companies Act for winding up or liquidation? Because under Companies Act in your CA Inter also, I think you must have studied a chapter known as liquidation of companies, right? And there was a fixed format: liquidator expenses, liquidator costs, secured creditors, government dues, statutory dues, yes or no? So preference will come and fixed format was there. IBC says change the format. That format we don't want to follow under IBC. I said, why? What is wrong? They said under IBC, why should we follow that format? I said, what is wrong in that format? They are very clear. They said, why are you giving priority to payment of government taxes and government dues? Why? IBC says if government does not receive the money on priority, will the government shut down? No. But if the creditors or the employees who have worked for the company, given funds or money to the company or goods to the company, if they don't get their money, maybe they might suffer more. So let's change the entire model. Okay. How do we want to go forward? I said, see, very simple. First of all, pay the professional fees, that is liquidator cost and the liquidation expenses, whatever are incurred, pay that. Okay, paid. Second, sir. Second, call those workmen of the company. Call those workmen of the company who have worked with the company and more than 24 months have passed, but they have not received remuneration. Call those the secured creditors who have relinquished their securities. So for secured creditors, I'll tell you there are two options. One, you are my secured creditor. This is your security. Take the security and go. Simple. You are my secured creditor. This is the security. Take the security and go. Easy. Option number two is you are my secured creditor. Come to me and give it to me in writing. You do not want the security. You want the money. Meaning what? Relinquish your security. Now what will happen? You have given 5 lakh rupees to the company. Company has given you some security. Value of the security is 4 lakhs. Okay. So if you are taking the security, take the security. Don't show me your face again. Finish. Transaction over. Zero. End. If you are relinquishing your security, in that case, how much is the value of security I told you? 4 lakhs. How much did you give the company? 5 lakhs, right? Okay. Right now, in point number 2, because you have relinquished your security, you have the security, so I should give you the priority. I will give you the payment on priority, but it will be a payment on pari passu basis. Pari passu means equal footing. Meaning what? If I have to pay 60 rupees to the secured creditor and I have to pay 100 rupees to the workmen more than 24 months old, no remuneration given. 100 rupees to them, 60 rupees to this person, secured creditor, and company has only 80 rupees. So company will not pay any particular person on priority. That 80 rupees will be bifurcated in 60:100, 6:10 ratio. Understood? That is 3:5 ratio. And accordingly, both of them will get proportionately equal payments. Is that clear? Okay. If the company has enough money to pay off them both, company will pay them both. But secured creditor, when company has enough money and company is making payment to you, your 5 lakh of debt is there, no? Security value is 4 lakh which you relinquished. You will get 4 lakhs only over here because that is the value of your security. We are not saying other 1 lakh you will not get. You will get. But that 1 lakh, there is no security, no? You will get it with or after the unsecured creditors. Okay. Come in the end. So you got something. Let everybody get something at least. Okay. So first, liquidator cost, liquidation expenses. Second, workmen who have not received remuneration for more than 24 months, and secured creditors who have relinquished their security, so to the value of their security, pari passu payment will do. Third, those employees of the company who have not received remuneration for more than 12 months, make payment to them. Fourth, unsecured creditors of the company, call them. Unsecured creditors of the company, call them, make payment to them. Fifth, statutory dues, government dues, whatever are pending, call them. But tell them, government dues, yes, that secured creditor who had relinquished his rights. So 1 lakh was pending. That 1 lakh was pending. So that secured creditor, balance amount, and that government dues, pari passu payment again, proportionate payment will be given. Understood? And after that, all the remaining debts and dues, everybody will be paid proportionately if any funds are left. This is the priority for distribution under IBC, known as the waterfall model, given under section 53. So this entire thing which I explained is your process of CIRP and liquidation. Next, I will show you PPIRP also. Okay, but for that, I will have to show you the screen. Okay, so now I'll just brush through the concepts from the screen also and show you PPIRP as well. All right, let's shift on to the screen. Now, talking about insolvency bankruptcy code, what are the important things that I have to show you? First of all, have a look at this. Composition of IBC, yes or no? IBBI, Insolvency Bankruptcy Board of India. How many members will be there? 1, 3, 1, 5. In SEBI, this was 1, 2, 1, 5. Yes or no? 1, 3, 1, 5. 1 will be chairperson, 3 will be members from the Ministry of Central Government, 1 will be from the RBI, and 5 will be other members, out of which at least 3 should be whole-time members. In SEBI, if you remember, it was same, everything same, only instead of 1315, it used to be 1215. Okay. Then, let's go to, yes. The waterfall model, that is the priority for distribution, the payment model. Okay. How or what is explained over here? Let's have a look. First, you will make the payment for the insolvency resolution process cost, liquidation cost. Second, they are saying rank equally. At number 2, rank equally. Rank equally means pari passu payments. For what? Workmen, more than 24 months. And you have secured creditors who has relinquished his security. Third, you have wages. Wages unpaid dues to employees. Employees, but other than the workmen. Okay. More than 12 months. Okay. So your workmen more than 24 months, employees apart from workmen more than 12 months. Sir, whoever are balance will come later on. Okay, we'll talk about them. Then you have unsecured creditors. Yes. Then again pari passu, rank equally, again pari passu. For what? Central or state government dues. Yes or no? And that secured creditor who relinquished security. Yes or no? Security value 4 lakhs, total debt 5 lakhs. 4 lakhs we gave him at the time of relinquishment. Balance 1 lakh will get over here. Okay. And then your other remaining debts or dues. Understood? This is your priority for distribution of payments. Then we talk about CIRP. In CIRP, what did we say over here? Minimum amount of default. Minimum default. If you want to come under IBC. Okay. So for starting CIRP, minimum default amount should be rupees 1 crore. And for starting PPIRP, minimum default should be rupees 10 lakhs. Is that clear? Rupees. 1 crore, 10 lakhs. Is that easy enough? Clear? Okay. Then only you can come under CIRP. Who can file application? We have already seen financial creditor, operational creditor, corporate debtor. Everybody can come and file applications over here. Okay. Then I'm going on to another portion of time limit for completion. We have discussed 180 days plus 90 days, but can be extended up to total of 330 days. Okay. Option, if you want to withdraw the CIRP, withdrawal also can be done, but you remember for withdrawal we need 90%. Moratorium period. What is moratorium period? Maximum 180 days that we have seen already, plus 90 and 330 that will remain as it is. During this period, starting, or you can call it institution or continuation of any suits not allowed. transferring or encumbering or any ownership, any membership of shares during this period, not allowed. Foreclosing, meaning action for forceful closure, yes or no? Foreclosing or recovery under SURFACI Act or any other law, nothing allowed, yes or no? Then, yes, moratorium period will be effective for 180 days. No, never say that. It will be effective from commencement of the CIRP to completion of CIRP. When will CIRP start? When the admission of application, when the application is accepted, CIRP will start. Is that clear? If before 180 days your corporate insolvency resolution plan, CIR plan, if your plan is ready before 180 days, moratorium will finish before 180 days itself. So what you will do when the moratorium starts? First of all, immediate public announcement. Immediate over here means within 3 working days. Public announcement to be done. After public announcement, you will give your details, public, your creditors to submit their claims so that you can bifurcate the creditors. Your IRP. If any false claims are received, then penalties for that. Yes or no? And the last date of your CIR. This is all you will give them over there. And IRP will be okay. Now here, what is the term of IRP? Till the appointment of RP. If you are only appointed as RP, continue. Otherwise, if 66% majority, they can replace the RP till the new RP will come. You can continue. Okay. Entire company, all the employees, workmen, management to extend full cooperation for during the CIRP. That is the process. Committee of creditors. IRP will constitute the committee of creditors. Committee of creditors will comprise of financial creditor only. If one person is financial as well as operational creditor, then he will become a member of the committee of creditors, but his voting rights will be limited to the extent of the financial debt only. Then, sir, decisions of COC, all the decisions shall be taken by 51%, not less than 51%. When nothing else is mentioned. Where it is mentioned, it will be 66% only, and everywhere almost 66% is already mentioned. Okay. Then whatever is required by the member COC, RP shall make it available within 7 days to them. I already explained at the time of discussing it with you. Okay. If no financial creditors are there, or all financial creditors are related parties, then as we already discussed, 18 plus 1 plus 1. Top 18 operational creditors by value. Okay, plus 1 representative of workmen and employee. Meetings, as we said, COC meetings. Yeah, meetings, as we said, COC meetings can be held as and when the RP feels necessary. If the committee of creditors want to hold any meeting, at least 33% of them should make an application to RP. Quorum, 33% required. Quorum not present. Next day, same time, same place, adjourned meeting shall correlate with whatever is present. So nothing more to do over there. Then I'll take you to replacement also can be done of RP with 66% votes. So no major change over there. What else is there? Liquidation process. First of all, let's talk about liquidation process. No plan presented, company goes to liquidation. Plan rejected by COC, plan goes to company goes into liquidation. COC fails to approve the plan within that period. Plan was ready, but they did not approve it. Company goes into liquidation. NCLT rejects the plan, plan goes into liquidation. Okay, company goes into liquidation. Now what? Liquidation has happened. So RP will become IP, or he will be replaced by the adjudicating authority and someone else will come in as IP. Okay. So 66% votes, same will be required. No problem over there also. The liquidation estate. What does it mean? Do the valuation of all the total assets of the company. Okay, do the valuation of all the total assets of the company. I'm running through these notes, brushing through these notes quickly because I've already given them to you. Okay. And then I am going to take you to another important concept of PPIRP. Now, before I go to PPIRP, where is my PPIRP gone? Let me find the PPIRP. PPIRP, pre-packaged insolvency resolution process. Okay, by the time I open the notes, you can just listen to what I'm saying. Pre-packaged insolvency resolution process means what, guys? It is a concept of IBC, same process of CIRP, but only and specifically for MSMEs only. So if you are an MSME, you will fall under PPIRP option. It is an option. It is not compulsory for you also. Okay. If you don't want to go through PPIRP, you can always go through. This is now May 23. I want. Okay. Yeah. So you can always go through CIRP also. MSME can do CIRP? Yes, sir. Of course. Why not? MSME can definitely do the CIRP if the amount of default is more than 1 crore. If the amount of default is not more than 1 crore, then it will not do the CIRP. So then what will they do? Then they will have to go for PPIRP only. Is that clear? I'll just get the notes of PPIRP for you. Yes. See guys, to understand this concept of PPIRP, what you need to do first of all is read this with me. If this you understand, you will understand PPIRP. What is this? The basic difference between CIRP, Corporate Insolvency Resolution Plan, and PPIRP, that is Pre-Packaged Insolvency Resolution Plan. Okay, this is your basic difference between CIRP and PPIRP. I have also made a separate video to explain PPIRP process alone in proper detail. Okay, if you want that, you can message me for that also, and I'll share the link of that video with you. You can watch it at your convenience. There is no issue. Okay. Here, very crisp explanation I'll give you. CIRP, you can go when minimum amount of default is 1 crore, but PPIRP has to be 10 crores, 10 lakhs. I'm sorry, 10 lakhs. Okay. Sir, under CIRP, application to do CIRP can be given by anybody, as we said. It can be given by the company, that is the corporate debtor itself. It can be given by the financial creditor or operational creditor, anybody. But in case of PPIRP, only the MSME, that is the corporate debtor itself, can make an application to do the PPIRP. Sir, if any application is filed against in CIRP, it will be filed against whom? It can be filed against company for CIRP. Yes or no? Similar process will be there for LLPs also. For individual partnership firms also, we have options over there. Correct. But when you talk about PPIRP, it is only and solely for MSME only, nobody else. Sir, in case of PPIRP and CIRP, there is a shift of control. In case of CIRP, from shareholders to creditors, there is no control shift over here. Company's management itself is going to run the show. In PPIRP, then all the financial creditors, or if there are no financial creditors or all of them are related party, then we said 18 plus 1 plus 1. Here we will say 10 plus 1 plus 1. Okay. Moratorium was maximum 180 days. Here it will be maximum 120 days, but that won't be 120 also. It will actually be written as 90 plus 30. How 90 plus 30? I will explain to you. Okay, patience. Resolution plan is prepared during moratorium under CIRP. Under PPIRP, a base resolution plan, we call it BRP. A base resolution plan is already prepared in the initial 90 days before making application that I want to do the PPIRP. Okay, when you make the application for PPIRP, the company itself is making application. So the company knows its financial position, right? Company will make a plan and keep it ready. Company will make a plan and keep it ready. All set, go. Keep it ready and then make an application. Understood? After the application is made, the base resolution plan is already there. Committee of creditors will be made by resolution professional, everything that same process we follow. And then alternative resolution plans will be generated, made, developed, maybe called for, invited. Then the base resolution plan and different alternative resolution plans, if anybody has suggested, we will compare and select the best alternative plan available. And that we will submit to the tribunal. Understood? So that is an interesting point in PPIRP. Public announcement, we said it shall be done within 3 days. In CIRP, here we are talking about it within 2 days. CIRP starts after application is filed by corporate debtor or financial creditor or operational creditor. But in case of PPIRP, pay attention over here. First of all, PPIRP process will normally start 90 days before you make the application. So when the date of application of PPIRP, we call it as the T day. So T minus 90. Before the T day, 90 days before that, you are going to make the base resolution plan. So it will be started. Then your T day will come. From that T day, you have 90 days. 90 days to select the best alternative plan and give it to the tribunal. The best alternative plan, you will give it to the tribunal at the within this 90 days period. Then within the next 30 days, tribunal is going to approve your plan. Understood? So that is why we call it 90 plus 30. Is that clear? This distinguish is super, ultra, pro, max, alpha, beta, gamma, delta level important for you. Understood? Make sure you have a note of this with you at all times. And along with this, if you want, just message me. I'll give you the link also for the answers. PPRP answer in detail. Make a note of this somewhere first. Done? Clear? Shall I proceed? I hope you have taken the photos or screenshots, something. And here I come to the explanation. See this. Pay proper attention over here. Huh? See this. So see the first timeline on the screen, which is on the top. Okay. That is CIRP. Admission of application started. 180 days is your moratorium period. Within this period, you have to make your plan. Simple CIRP. Now you see the second timeline, which you can see below. There you can see, first I'll mark it over here. Okay. So it will be easier that way for us. See this. This is my T day. That is, application is made by the corporate debtor, that is the MSME, that we want to go for PPIRP. That day will be treated as a T day. Now here, when the application is made for PPIRP, during that time, we are saying T minus 90 days. Meaning 90 days before that application, they will start making a plan with the help of resolution professional, because company itself is going to do it, right? So company has an interim resolution professional in-house appointed. So they have appointed informally. Official appointment will be done by the committee of creditors, but that will be done only after this day. Okay. So right now they are making a base resolution plan and they are submitting it on the T day. Within T plus 90 days, evaluation of the BRP, that is the base resolution plan that you have given, and any other alternative resolution plans are coming, their evaluation will be done, and then out of them both, the BAP, that is the best alternative plan, will be selected. This plan will be given to the tribunal, and in the next 30 days, the tribunal will give their approval whether it is in public interest and worth implementing, or we should put the company into liquidation. If tribunal feels liquidation, the company will end up going into liquidation. Is that clear? Along with this, one more point I want to discuss with you is yes, these three questions over here. If creditors have already made an application for CIRP, and then the company makes an application for PPIRP. Understood? We are talking only for MSMEs. Huh? Company MSME makes an application for PPIRP, and the default is more than 1 crore. So CIRP also can be done. So in that case, PPIRP will continue or CIRP will continue? That we have to answer over here. So first case, application for CIRP is filed after application of PPIRP was already filed, then PPIRP will continue. Second, application for PPIRP is filed within 14 days from the date of application of CIRP, then PPIRP only will continue. But if CIRP application is already filed and your PPIRP application you are filing after 14 days of your CIRP application, then CIRP will continue. Is that clear? Okay. So this is your simple concept of PPIRP. I hope this is now super clear for you. Okay. So I hope this is super amazingly super clear for you. And after this, we'll go on to the next part. Okay. So I think for IBC, I am not going any further. We'll stop IBC over here itself. If you have any other specific questions or specific doubts, like specific doubts, get back to me on WhatsApp very easily. I'll be able to get back to you. I'll be able to answer you. Okay. Those who do not have my WhatsApp, I'll give it to you. This is the WhatsApp. Only WhatsApp, no calls on this number, please. It is WhatsApp, official WhatsApp. Okay, you can drop your doubts, your particular queries on this. You want any other notes, any other books, any other guidance, anything you want, you can drop it on this. Understood? Me and my entire team will be super happy if we are able to help you in any way that we can. Understood? So yes, just a small tiny push from us on your journey to become a chartered accountant. All right. So I'll stop with IBC over here and we'll go on to the new chapter. All right. FCRA, Foreign Contribution Regulations Act. What is this law about? Foreign Contribution Regulation Act. Let me revise this law very quickly with you. Okay. I understand you all must be already tired. Some of you have already left also, I see. I'm pretty sure because such a long lecture, non-stop, very difficult to stand by, very difficult to attend, right? So yeah, I understand many of you might have already left too. So it's okay. I can understand. And I hope the recordings will be available. So you will go through the recordings and revise the portion quickly as per your convenience. Okay. So FCRA. See, FCRA in this chapter, no, you have to remember a couple of words, that is foreign contribution and foreign hospitality in the first part. Okay. Foreign contribution and foreign hospitality. What is foreign contribution and what is foreign hospitality? Both the things, both the questions are something we have to answer. Okay, let's answer. What is foreign contribution? Foreign contribution, very simply, I will explain to you. DDT, donation, delivery or transfer of any goods, any material, any currency, anything which is coming from outside India to inside India. Understood? So contribution will include what? DDT, donation, delivery, transfer. Everything will be considered as a part of foreign contribution. Hospitality means what? If you have received any offer, not a casual one, a formal offer, yes or no, where your lodging expense, boarding expense, everything is borne by someone in the another country, then you are receiving foreign hospitality. Okay. Now, can we accept foreign contribution? Yes, of course you can accept. Can we accept foreign hospitality? Of course you can accept. Yes or no? Of course, we all do accept also, right? Like if I have a relative in abroad and if I go over there, they sponsor my entire trip on their land. Yes or no? My traveling, lodging, boarding, everything is taken care of by them. And plus, when I return, they'll give me some expensive gifts too. So, this provision that we are supposed to learn is not for you, not for me, not for common people like us. But these are the provisions that we have to learn for people who are covered under Section 3 for foreign contribution when I talk about it, and people who are covered under Section 6 when I talk about foreign hospitality. So basically, who are these people? In our today's generation, we call them as influencers. What do we call them? Influencers. These are influential people. And when I say influencers, I mean no connection with your Instagram influencers. All right. When I say influencers, these are all genuine, big influencers apart from the tech influencers that we are having today. These people can be like government employees, government servants, public servants, whom you call. They can be newspaper editors, newspaper publishers, columnists, cartoonists, newsroom readers, newsreaders, that is we call them. So any of these people are having the power to influence people. So here what we are saying, if they are receiving any foreign contribution, if they are receiving any foreign hospitality from any unknown source or any source who is unauthorized, yes or no, or any kind of hospitality or contribution that they are receiving, but in return they might have to give some services or provide some news for them or do something in return which might just turn out to be disadvantageous to India. In that case, we will not allow them to do it. Understood? We will not allow them to do it. The a classic example of this I can give you is fictional example if you want. There is a web series known as The Family Man 2. In that they have talked about assassination of prime minister, assassination of Indian prime minister. Okay, so how the funds are being sourced from London through a particular person. Okay, so how Bhaskaran was the name of the character, I very clearly remember. So how the funds are sourced from there, funds are coming to India, how are the channels connected of different countries and how it is done. So that is one thing that can happen if we allow FCRA without any restriction. Yes or no? One very recent web series again came out known as Farzi. If you have seen that also, you will come to know they are talking about counterfeit currencies. If we allow Indian currency also to come inside India freely, then Indian currency in the form of counterfeit notes also will be coming into India. And considering Indian currency, you won't have any check on that, and then it will lead to unnecessary inflation in the Indian economy. A realistic example, if you want, you can read about Rajiv Gandhi assassination case. That also was a very famous case that happened, very prominent and not a good thing that happened in India, I would say. There is a movie based on it known as Madras Cafe. If you're a movie fan, you might be aware, or you can just watch that movie. I mean, after your exams, of course, now. But you will come to know about how money or things or weapons or arms can be sourced into India. Understood? From sources outside India. So when these things are coming into India from outside India, we call it as foreign contribution. Or maybe when I go outside India, they provide me free food, free travel, free lodging, boarding, everything. And then in return, they expect me to do something else for them in India, which might not be allowed in India. That is foreign hospitality, where we are prohibiting people under Section 3 and under Section 6 from receiving foreign contribution or foreign hospitality, of course, subject to exceptions, subject to exemptions also. Understood? So that is what we have to talk about under FCRA. Now, if you want to do FCRA transactions, you want to do any FCRA transactions, we'll give them registration related options also. We'll give them options for registrations also. Registrations we'll give them in two types. One will be a 5-year registration option and one will be OTR. That is one-time registration, but you cannot call it OTR. So we'll call it as prior permission of CG. Prior permission of CG. Before every transaction you do, you need to obtain a prior permission of central government. Okay. This way they can get registered and then do the transactions. But once you are registered, remember, inflow of forex will come in a single bank account. Okay. And that has to be located with SBI New Delhi branch. And after this, outflow, or you can call it utilization, can be done through multiple bank accounts. No problem. Understood? Multiple bank. It should come foreign money, which is coming after you have received the prior permission for one-time transaction, or if you are registered for 5 years, inflow, it is coming. It should come to a single bank account, that is SBI New Delhi branch, and then utilization can be done from multiple bank accounts. So you can have it bifurcated over different accounts. All you have to do is maintain accounts. Maintain accounts means what? What do I mean by maintain accounts? Accounts means opening balances plus inflows minus utilizations and your closing balances. Understood? These type of records, these type of accounts shall be maintained. When we talk about inflows, we also want to know the source from where the funds are coming. And when you talk about utilization, we also want to know where are you utilizing. For verifying this, they will be conducting audits. These audits will be done by whom? These audits will be done by gazetted officers of Group A class. I'll give you examples like IAS officers, IES officers, or DGP level of officers. They will be doing the audits over here. Understood? They will be responsible for the audits over here. Is that clear? So basic provisions I am explaining to you. Can you renew your registration of 5 years? Can you renew? Yes or no? Yes. When can you renew? When can you renew? Answer is during last 6 months before expiry plus prescribed fees should be paid for renewal. Now, this registration which you have got, can it be cancelled or can it be surrendered by you? Yes or no? Or can it be suspended? Yes or no? So first question is, if it is cancelled, who has the power to cancel? Central government. Who has the power to suspend? Central government. Surrender is suo motu. Right? If it is cancelled, in that case, 3 years cooling period. You cannot have a new one for 3 years. New license for 3 years. If it is surrendered, you have to give reasons for surrender. And if it is suspended, it can be suspended for maximum 180 days plus extension of maximum 180 days. Not more than that. Then it has to be restored. Understood? The simple points are there. See, I'm just making a note of these points and the chapter will get over. You won't even realize. Understood? Use simple points which you need to first on priority focus when you are reading this chapter. Now, this is a person. He has a, what do you call it? Registration for 5 years or maybe prior permission. Okay. And he wants to transfer, not utilize, not utilize. He wants to transfer the foreign contribution that he has received to some another person. This another person also has a registration or prior permission, whatever is the case. Understood? The law says this is not allowed. There is a blanket prohibition. What is there? There is a blanket prohibition. Blanket prohibition means what? Means you are not allowed to transfer these funds. You have received it for a particular purpose of utilizing it for a particular purpose. Utilize it, and that means in that way only. Understood? That's what you have to remember over here. Is that clear? Yes or no? So that's what blanket prohibition means. Now, when I say suspended, now my license is suspended. Okay. My registration is suspended. Now, during this suspension period, I have already received some foreign contributions and some payments are due. So, can I make such payments during the suspension period? So, question is it allowed or not? So, I will say over here, suspension is done. And during suspension, you want to make any payments? First, you can make up to maximum 25% of whatever you are having. Maximum 25% of whatever you are having, you can do, but that will be subject to CG approval during suspension period. Okay. And balance amount which you are having, it cannot be utilized. Only after suspension is revoked. Not before that. Only after your suspension is revoked, you will be allowed to utilize that money. Understood? Clear, everybody? Yes or no? Remember one very important thing when we talk about FCRA provisions, if there is any kind of contradiction with any other law, FCRA does not override any law. Okay, FCRA is in addition to every law. Understood? So when you are reading FCRA, you have to understand FCRA never talks about overriding the provisions, applicable provisions of any other existing law. No. FCRA specifically specifies that you have to comply with the provisions of FCRA in addition to the provisions of all the other laws. Is that clear? Yes. This is the most very important portions, as we say, that you have to study from this chapter. Okay, very important portion. I hope this is clear. Okay, I'll just scroll this through, then I will go to the notes and do some markings for you that you need to understand from this chapter, and then we'll proceed. Ready? Shall we rush through the FCRA portion? See, starting with when you read it from my notes over here, first we have given the meaning of foreign company, foreign contribution, as I said, donation, delivery, transfer. Okay, all the three words you have to talk about them. Then we have also talked about foreign hospitality. Meaning of foreign hospitality is also given. Foreign source, when I say money coming from outside India, foreign source, what do you mean by foreign source exactly? That also we have explained. Then we talk about section 3, prohibition to accept foreign contribution. FC is not foreign currency, foreign contribution. Okay. Now, what is the prohibition? To whom the prohibition is there? Election candidates, public servants, or judge or government employees, political parties, any companies or associations or columnists or cartoonists or editor of audio, video, news, broadcast business, and similar people from the registered newspaper business or any member of any legislature, what we call. Okay. So all these are what? Prohibited people. Now, they are not allowed to accept. You are not allowed to accept on behalf of them. You are not allowed to accept if you believe that you are accepting it on my behalf and I am going to give the money ultimately to them. Then also you are not allowed to accept. Is that clear? So that we have explained over here. Okay. Then we have section 6, foreign hospitality, who is not allowed to accept. If you understand, same provisions are there. Hospitality is not allowed, but if you are like a diplomat, yes or no, and of course you are not allowed to accept foreign hospitality, but there is an urgent medical aid that you had to take. Who are you? You are any member of legislature or political party, office bearer, judge, government employee, government servant, and you are going outside India, and you have to get some urgent medical aid. In that case, provision says it will be allowed. Urgent medical aid will be allowed, no problem. You can take it, but whatever urgent medical aid you have taken, you have to inform the central government within a span of 1 month. Okay. There are certain changes, certain amendments also over here in FCRA. Small provisions have changed. So for those amendments, in my latest notes, all the books, all the what do you say, amendments have been incorporated. You can simply refer Harsh Kachalia amendment video on YouTube, where part 1 of amendments, that is all the amendments of all the chapters except for that FEMA part, are already given, already recorded. When you refer to these amendments, you will get the PDF of the amendments here also. You will get it on Edujahan download section also. Okay. So that video is also all set and all ready and given to you. I hope that will also be helpful for you for last minute, very quick revision, because it's a very short and a crisp video where the amendments have been explained fantastically. Okay. So I hope that will be helpful to you. So please go through that also. Okay. Go through that also and let me know if you need anything else. I will be happy to help. Next, I'll take you to registration. Registration will be with central government for 5 years, or maybe you can take a prior permission and do transactions individually. Up to you. Okay. Provision says what over here. Certificate of registration will be granted. Yes or no? Or prior permission will be given. You need to make an application to central government if you want it, and then you have to open an FCRA account. Understood? Open an FCRA account. Now, then the provision which I need to take with you, procedure for grant of certificate, how will it be granted? Make application. If application is in the prescribed form with all particulars required, no, it will be rejected. If yes, permission will be granted. If it is for 5 years, then 5 years or prior permission will be granted. Normally, it is done within a span of 90 days. Suspension, we have already talked about it. Yes. CG has the power 180 plus 180 utilization during that period. 75% with CG, 25% with CG approval, balance not allowed. Cancellation also can be done by central government. Once it is cancelled, cooling period of 3 years is attracted. You cannot again get a certificate or prior permission for the next 3 years. You can also surrender your certificate if you want. CG will conduct the necessary inquiry and accept your certificate. Understood? Then renewal purpose. See this. Certificate was granted to you. Yes, sir. Certificate was granted. Yes, sir. 5 years expired. Yes, sir. Yes. Then it cannot be renewed. 5 years expired. No. No, sir. No, sir. Then how much time is left? Sir, last 6 months are only left. 6 months are only left. Yes. Then you apply for renewal to CG with the prescribed fees. Sir, fees as in, should I pay cash? Nope. No cash. Only DD or online payments only. If you do not give fees or you do not make an application, your existing certificate will lapse. It will be cancelled. You can then apply for a fresh certificate directly. Is that clear? With respect to accounts, as I said, receipt will be in a SBI New Delhi account, single account. Open another FCRA account for utilization. We have no issues, no problems. You may open one or more account for utilization. We have no restrictions over there as well. No funds other than foreign contribution will be received in this particular accounts. No funds except FCRA. FCRA Act, FCRA funds only. Okay. Then every person has to make some disclosures, as we said. About disclosure about what? Amount that you have received, source from where you have received, yes or no, purpose for which you have received, and how you are utilizing that money. That statement you have to give with the particulars to the central government. Maintenance of the accounts, as we said, you have to maintain the accounts of source also, that is receipt also, and payment also. Both you have to maintain. Audit will be done by gazetted officer of group A post. Examples also I have given to you. Okay. This is easy part. If you are not satisfied with the order of cancellation or any order passed against you, you can file an appeal also. Okay. So with respect to appeal, how you will file an appeal? If amount involved is up to 10 lakh only, then to the assistant sessions judge. If it is more than 10 lakhs, then sessions court, that is sessions judge. Okay. Any order which is already passed can also be revised, but for revision purpose, what they are saying, revision can be done suo moto, or revision can be done on the basis of your application also, but only condition is whenever the order is passed for which you are not satisfied, if you want any revision to happen, within 1 year you have to apply for revision. Only then revision will be done, otherwise revision will not be done. Is that clear? Okay. Lastly, these are simple concepts. I'm sure you'll be able to do them. Here. This is the point. Act not to apply to government transactions. Government to government foreign currency transactions are happening. FCRA will not apply. And FCRA shall be in addition to the other laws and not in derogation to the provisions of any other law. Okay. So I hope this will give you a synopsis about how easy this chapter is. Like really how easy this chapter is. Understood? And then you can proceed and finish off this chapter. And I'm wishing you all the very best now. But just hold on. So guys, before we wind up for our revision class, let me revise the compromise arrangement and amalgamation portion. Of course, not the entire chapter won't be possible, but yes, see, this is the basic bifurcation that we have made for your chapter. Okay, compromise arrangement and amalgamation. So your compromise arrangement part is the part 1, amalgamation is the part 2, and some miscellaneous provisions is the part 3. That is how this chapter is divided. This chapter is covered between section 230 to 240. Okay, 230 to 240. Now, when we talk about 230 to 240, 230 and 231 is a part of your compromise arrangement. 232 to 238 is a part of different types of amalgamations. And 39 and 40 are simple miscellaneous provisions. Okay. I have also given you an ABC analysis, as you can see on the screen. A category, B category, and C category of the sections weightage wise that you have to do from this chapter. I'll quickly go through your A category portion for that is 230, 232, and 233 for you. Okay. What is A category portion? 230. First of all, 230 talks about compromise and arrangement. Compromise and arrangement. That is your section 230. Now, what is compromise and arrangement? So, there is a company whose financial position is very bad. Very bad. Very bad as in it is so bad that the company might just shut down. Okay. But there is someone who does not want the company to shut down. There is someone who does not want the company to shut down. It can be the company itself. It can be any creditors of the company. It can be members of the company. It can be directors of the company. Or maybe they have already given an application for liquidation, and the liquidator, after doing valuation of all the assets and liabilities, the liquidator feels that the company should not shut down. So any of these people who feel that the company should not shut down will make an A for application to the tribunal. Application to the tribunal saying what? Please help us save this company. How? So along with this application, they have to submit a plan. A plan, but we don't call it a plan over here. We call it a scheme. Scheme of compromise and arrangement. Okay. How are you planning to save the company? You have to submit along with the scheme your application to the tribunal. So to understand this answer, I'll give you a keyword. Okay. It is ado. What is it, ado? Ado. Ado. Ansor. Ado. Ansor. Dabata. Dabata. Dapta. Ado ansor dapta. Now what is ado ansor dapta? Pay attention. What is ado ansor dapta? See, meaning of this keyword is absolutely nothing. You don't like the keyword? Don't even dare to change it. Why? Because this is the procedure. They are the steps. Only after A you can go to D, and only after D you can go to O. They are the steps. And one more point I will tell you. If you remember this answer along with the keyword as I have written it over here, you will end up remembering it with the applicable subsections that are there for this section. All points are different subsections where it starts from A for application to the tribunal. Okay, so let's quickly run through them. Ado, Ansur, Dapta. A for application to the tribunal. Okay, now pay attention over here. Here where they are writing tribunal, no? Here I will alternatively I will write central government. Why? Sir, if you are talking about compromise arrangement of government company, then this application should go to the central government and not to the tribunal. Otherwise, application to the tribunal. Okay. Now, once you make this application to the tribunal, what tribunal will do? Tribunal will ask you to make certain disclosures. Green. Where is my green? Where is my green? Tribunal will ask you to make certain disclosure. Disclosures like you are saying what? Your financial position of the company is bad. Prove it. Prove it. Show me your material facts about your company. Like, show me your audit report. Show us your financial position of the company. Yes or no? Have you done any reduction in the share capital? Show us evidence with respect to reduction in the share capital. Corporate debt restructuring done? Yes. What is your scheme of corporate debt restructuring, meaning restructuring of debenture holders if you have done? Show us that also, whether it is approved by at least 75% of the debenture holders of the secured creditors. Yes or no? Prove and show all these things to the tribunal. After seeing all those things, what tribunal is going to tell you? Tribunal will tell you, go call and hold the meeting. Go and call and hold the meeting. How will you go and call and hold the meeting? See, provision very simple. At least 1 month before the date fixed by the tribunal for holding the meeting. Okay, you have to send the notice to all the members, all the creditors. Who will send? Tribunal will tell you who have to send. Company, maybe chairperson, maybe liquidator, anyone. That tribunal will decide. It shall be sent to all of them, all the creditors, members, debenture holders, everybody. You can send it by registered courier, post, hand delivery, electronic means, however you want. When you are sending the scheme, along with the scheme, send the details of your compromise arrangement scheme, draft, summarized. Send a copy of your valuation report because you are saying that the financial position of the company is weak. The liabilities are almost more than the assets. Show your valuation report to prove it. And then if the compromise arrangement is done, how will it impact or what will be the effect on the creditors or promoters or KMP or shareholders or the company? Show them that also. Understood? When you are calling them for the meeting, you are sending them the notice to come and take a decision whether compromise arrangement should be done or not. You have to disclose all these things to them. So, did you disclose all these things to them? Yes, sir. Along with this, they are saying when you are sending this notice, no, Make a disclosure on the website of your company, and if you are a listed company, SEBI and stock exchange website also you have to disclose. Plus publish it in daily newspapers of English and Hindi language. Understood? Wherever you are publishing, specify that the detailed scheme of compromise arrangement is available at the company for verification by anyone who needs it. Okay, so make that disclosure over there. A for application to the tribunal, D for disclosures as required by the tribunal, and O for tribunal is passing an order for you to call and hold the meeting. Okay, so you are busy calling and holding your meeting. Okay, what tribunal will tell you? Tribunal will also specify who can attend the meetings and who can raise objections over here. Meeting can be attended physically also, by sending a proxy also, or by postal ballot also. Raising objections at this meeting shall be allowed by shareholders, yes, if at all they are holding in the company is not less than 10%. Not single shareholder 10%. Group of shareholders together also not less than 10%. They can have a representative who will raise objections. In case of creditors, not less than 5%. Understood? Then we talk about notice to be given to the statutory authority. This will be done by the tribunal. Tribunal will, number one, send a notice to all the statutory authorities and ask them for their opinion to be given to the tribunal within 30 days. How do they feel about the scheme of compromise arrangement which has been proposed over here? Okay, and then a sanction of the scheme may be granted. Sanction of the scheme may be granted, but before tribunal sanctions the scheme, company should get the scheme sanctioned in the meeting by the members or creditors. How? Minimum 51% of the members present in number, whoever is present and voting, 51% of them in number should approve, and whoever is approving, 51% or more, whoever is approving, they should hold minimum 75% of the paid up share capital. Understood? 51% in number and 75% in value of the share capital. Then it will be given to the tribunal. Tribunal will pass an order as it may deem fit. Yes or no? And whatever is the order of the tribunal, a chartered accountant, that is auditor's certificate, will be required to say that the scheme has been made, but it has been made after compliance to all the applicable accounting standards. Whatever is the order of the tribunal, go and file it to the ROC. Yes, whatever it is, you have to file it to the ROC within a span of 30 days. Is that clear enough? This is Ado Ansora. Ado Ansora. Let's go to Dapta. Dapta, dispense. Dispense means what? Withdraw. The creditors, if 90% or more, say that we do not want to meet up, okay, company can decide it on their own. In that case, if at least 90% of the creditors agree, in that case, you can withdraw the meeting of the creditors. But remember, no compromise arrangement will be allowed to be done if the company has done buyback and it is not as per the provisions of section 68. When I'm saying compromise arrangement, it can also be like I am compromising my entire stake in the company so that the company should live to see another day. I am compromising my entire stake. I'm giving my entire stake to you. What are you doing? You are taking over my company. So compromise arrangement includes takeover also. Understood? If you are a listed company, takeover, of course, it includes takeover. But this time for takeover, you have to comply with the SEBI takeover code. Understood? And last, if you are an aggrieved party, yes, you can file an application to the tribunal. Other than listed companies, any company, you can file an application to the tribunal. Is that clear? Understood. Once more, let's quickly have a recap of what we did. Quickly, Ado, Ansor, Dabta. Ado, Ansor, Dabta. That's what we said, right? 1, 2, 3, 4, 5, or maybe I should write it like this. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, and 12. A for application to the tribunal. D for disclosures as required by the tribunal. O for order to call and hold the meeting. Okay. A for attending meeting, raising objections. N for notice to be given to all statutory authorities. S, sanction of the scheme. Okay. Once sanction is done, order of the tribunal will be passed, which will be as a tribunal may deem fit, and whatever is the order, R for go and file it to the ROC. Last is Dapta, dispensing, meaning withdrawing the meeting of the creditors. B for buyback. Buyback, section 68 to be complied. takeover also included when you talk about compromise arrangement, and aggrieved party can go and complain to the tribunal. Is that clear? This is what your 230 section. Let's go to section 232. What is 232? Amalgamation or merger. Now, when we talk about amalgamation or merger, I'll give you a keyword over here also, guys. It is ado. Again, ado, all, fall, all, up. Sounds funny, right? Ado, all, fall, all, up, all, fall, all, up. What is important? Important. Okay. Ignore all the small things which is there. Small ll, ignore. Okay. This is also all your subsections. Okay. Very simple. Merger amalgamation process. What does it say? Let's have it. Let's have it in front of us. First, A for application to the tribunal standard that we want to do the merger. This application should be done. How? How? I am loving it. Yes or no? Benefit of doing subsections. Application to the tribunal, they are saying you have to make an application to the tribunal that you want to do the merger or amalgamation and comply with the provisions of section 230 subsection 3 to subsection 6 mutatis mutandis. What is it? Mutatis mutandis, meaning as it is, whatever you did under subsection 3 to subsection 6 of 230, same procedure you will comply with the application. If you do that, D for duties of the tribunal. D for what? Duty of the tribunal, what? To require you to provide assistance or provide the documents that you want to do the merger, how you want to do the merger. Understood? And then order will be passed by the tribunal. Simple as that. Order of the tribunal. Merger can be done or cannot be done. If can be done, what are the conditions? A for additional order can be passed by the tribunal. What do you mean by additional order, sir? Additional order means if at all, there is any charge created on any assets of the company, then as an additional order, tribunal will ask the company to free the property from the charge first. Understood? Charge means like a mortgage or something created on any property. Whatever is the order, go and file it with the ROC, and once it is filed, A for, in the scheme of amalgamation, A for appointed date will be given. In the approval of the tribunal also, appointed date will be mentioned. Scheme will be applicable. Amalgamation will be applicable from that date. But you for unless and until final completion is done, both the companies who are getting merged, both the companies have to do their independent compliances till the final proceedings of merger are over. You are existing, no? Do your independent individual compliances. Otherwise, we have penalties also. Here also same thing, A for application to the tribunal, but if you are a government company, you will make the application to CG. Clear? Yes or no? This is your 232. Okay, very quickly once more, 233 also I will take it up for you. Here, fast track merger. What is fast track merger? Pay attention. So what happens now? When we talk about merger, we have to comply with the entire process of ado, all, fall, all, up, all, fall. We have to comply with that entire process. Make application to the tribunal, wait for the approvals from the tribunal. So many things required to be done over there, right? But we don't want to do that. We want to take shortcuts. Why we want to take shortcut? Because sir, I am a small company who is getting merged with another small company. Maybe I am a holding company getting merged with a wholly owned subsidiary company. Sir, if we want to go for merger, why should we do the entire process of ado, all, fall, all, up? There should be some benefit for us. No, we are small, or it is like my own company, wholly owned. That yes. For you, we are keeping an option of fast track merger. What is fast track merger? Merger is done. Fast track merger is done, but no interference or approval of NCLT will be required. Merger will be done directly. So is that possible? Well, it is there in front of you. It is possible. Understood? How is it possible? See, first of all, the two companies who want to go for fast track merger take board of directors approval from each of your companies. Go to your companies respectively, take board of directors approval. Board resolution to be passed. Then send a notice to the respective ROCs and appoint liquidators also, official liquidators also, because your companies will shut down, liquidate, and then transfer all assets to the new company. Then convene a general meeting and take approval of shareholders also. Convene a general meeting, take approval of shareholders, 90% minimum should agree. After that, you need to go to the creditors. But before you go to creditors, this point is important over there. What does it say? Sir, before you go to the creditors, no, remember, you make a declaration of solvency so that your creditors do not think that you are getting merged. You are going under fast track merger. Why? Because your financial position is bad or you are going to shut down or anything like that. No, 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 no. No, no, no. That you don't do. Understood? Otherwise, go board resolutions, respective companies, go inform respective ROCs, liquidators, go inform, take approval of shareholders, respective companies. Wait, first obtain declaration of solvency for yourself and then inform the creditors. Once this is done, you can go proceed with your fast track merger. So tell the ROC liquidator, shall we start with the fast track merger? Now they will say if they have any objections. If they have any objections, if ROC or liquidator, if they have any objections, they will inform the central government. Okay, they will inform the central government and central government will check. What? First, objection. Problem is there. ROC, liquidator are correct. Fast track merger, not possible. Fast track merger, not possible. Then what CG will say? CG will say fast track merger not possible. Merger can be done always. That is your choice, right? Fast track merger not possible. So dismiss the fast track merger and put NCLT in between and comply with section 232 and do the ado all up procedure. But if CG feels objection, no. Nothing important. What CG is feeling, nothing important is there. In that case, what CG will do? If CG is satisfied, then CG will grant approval for fast track merge. CG will grant approval for fast track merge. Understood? That totally depends on CG. Now, what the provision says, if approval order is passed, what will happen? What will the effects? Let's come on the effects. Transfer of all the properties of old company to new company. Any charge created shall be enforceable like the property of the transferee only. So charges will be enforced. So no problem over there. All legal cases also to be transferred. Debentures or dissenting shareholders, creditors, everything. Payments required to be done shall be finished off. Shares of old companies shall be disposed of and new shares of the new companies shall be given. Say for example, A Limited share capital was 1 lakh for which they paid share capital fee, registration fee 1000. B Limited share capital was 2 lakhs, so they paid fee 2000. Now they are merging together. So now after merger, they have decided to increase the share capital, keep it to 3,50,000. So they will have to pay the fees of 500 only because 3 lakh of share capital is coming from old company only. Understood? For which 3,000 they have already paid. Is that clear? This is your fast track merger. I went really quick, but I went so because I'm assuming that you are already aware of these concepts. Okay, so that is where we are, and I hope you have understood these concepts. These notes, again, I'm saying, are available on our website also, edujahan.com, and you can get in touch with me also. I have shared my WhatsApp also with you, Instagram, Facebook, anywhere. You can ping me, and I and my entire team here at Logic, we will all be very happy to help you. All right. So a few last words coming up for you. Do not miss that. Make a note of them. Do's and don'ts for your exams. And then we will wind up the class. Thank you very much. So guys, my last few words. I understand all of you are very busy right now and just trying to cope up with all the lost time which you might have normally lost or abnormally lost, but you have targets already set to finish up your portions and you are striving really hard to get through it. Okay, so yes, I wish you all the very best for that. Just a few important things that I need to share with you. Let me just tell you. First thing, use black pen only. Do not use any other pen. Second thing, use black ballpoint pen only. No other variety of pen. Third thing, smartwatches not allowed. Analog watches only, because today digital smartwatches are there where you can have your whole WhatsApp chats and everything open in the watches itself. You can have your entire answers from your watches during your exams. So that is the reason analog watches only are allowed. Okay. So make sure you don't have to suffer any kind of embarrassment or what do you say, demotivation while you are all pumped and going for your exams. Make sure you revise the entire syllabus in the 1.5 day before your exam. If you are my student, you already know how to do that. We already have our class notes also set ready with us. This revision video, I hope it'll be very, very helpful for you. Guys, honestly speaking, if this video is helpful for you, do take some time, maybe just 1 minute of your day, and do let me know that yes, this video helped you or not, and how I can make it better. If you want, you can keep your suggestions also. I am all open to help you out in any other ways I can. Next point. When you are writing your answers, do not try to write the paper very, very neatly, because your paper might not get over in that case. Write in your normal, natural handwriting, readable handwriting, but at a very, very decent speed. Okay. The writing speed should be very, very decent, and it should be constant for 3 hours. Only then your paper might get over. Do not waste a lot of time on MCQs, because that's the mistake that students do. They spend almost 1.5 hour, 1 hour 15 minutes to 1 hour 30 minutes on MCQs only, which is 30 marks. And then you expect to finish the balance 70 marks of the paper in the remaining 1.5 hour or 1 hour 45 minutes of the time. Very difficult, guys. Very, very difficult. Do not do that. Okay. Then, whichever question you know first, you know best, attempt that first. If you don't know any internal question like A, B, C, D is there, you have written B, A, D, and you don't know C, leave space for it in between and then start a new question. By the end, if you find out that, okay, time is not there and time is already up and you don't have time to write the answer, with that same black pen, strike off that much space which is empty over there, so that nobody can write anything over there. And even if anyone writes anything over there, it is considered as nullified. Okay, it does not count. So make sure you do these small things, but make sure these things are properly done with you. Carry ample amount of your own water. Don't wait or call for water in the exam. That is all super waste of time. These are like very, very silly things where our students make mistakes and then they suffer wastage of time. One answer left out, two answers left out. Guys, your target has to be anything, but nothing less than 70 minimum. 70 to 75 has to be your target, and it is possible. Let me tell you, it is very easily possible for you to score that much marks. Very, very easily possible for you to score that much marks. All you need to show is a little bit of dedication, which I am sure all of you are super highly pumped and dedicated already. You need any help, do not hesitate to ask, because you are doing it for yourself. And I am also sitting here and helping, doing all these things for you only. Understood? I have no hidden agenda over here. As you can see, the video is given over here free of cost. So I don't have any hidden agenda, hidden income, hidden revenue, anything coming out of here. Nothing, nothing, nothing. Just because the portion is going to change very, very soon, hopefully in the next 1 year itself. And I don't want you to switch to the new portion and do all over the new things again. And law syllabus also may not be there. So better to clear it up with an exemption and finish it off. Because I need you to keep the result day in your mind at all times. Imagine that day of result in front of your eyes. Yes, you know that 2 o'clock, 12 o'clock, 2 o'clock result is going to come, and you are waking up at 8 o'clock in the morning and your hands are shivering already. Your hands are shivering, you are pressing refresh button. Also with praying, please don't come, please don't come, please don't come, please don't come, please don't come. And finally, when the page will hang and you will see that page, enter roll number, enter registration number. you will have a chill going through your spine. And then you will enter the roll number, enter the registration number. Now everything is there, sir. Who will press the submit? Who will press the submit button? Very difficult. Submit, submit, submit. Wait. P A S S, pass, 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 pass. Choked. Can't shout. Can't believe. Passed. Cleared. You are a chartered accountant. What a moment that. Thank you, thank you. You have so many people around with you tapping your backs. Yes or no? Giving you high fives, giving you hugs. You have your mom or dad, maybe your husband or wife, standing in some corner and relieved and weeping in tears. The tears of happiness. This will be the moment of your life, guys, where you will be super proud of yourself. Make sure you promise yourself this is the last day that you are seeing them cry, and not after today. They will never have to cry. Never have to cry ever again. Yes. And you have it in you if you have completed your CA Inter, completed your articleship, 3 years of struggle, 3 years of learning in your articleship you have done, and now you are giving your CA final exams. Maybe the first attempt or maybe the fifth one, doesn't matter. But if you are giving your exams today, you have already gone through a lot of things and you are just one step from reaching at the peak. And I don't see any reason why you should walk all the way down without having a feeling of how does it feel to be on the top. Yes or no? So make sure you do that. Aim for an exemption minimum. If you are giving both the groups, aim for the rank. I am not saying you will get it. I'm not saying you will get it. I pray you get it, but I'm not saying you will get it. But don't get discouraged, because if you aim for a rank and study in that direction, you know what they say in English? Always aim for the moon. Maybe you will end up hitting some stars. But very less time is left. So plan and study accordingly. I hope you are already having your plan, because also along with the saying which I already told you, they also say that if you fail to plan, it means you are planning to fail, right? So make sure you have a proper concrete plan for yourself. If you need any help, do let me know. If you want to join any groups for updates with respect to law papers, do let me know. Amendments are already uploaded on my channel. You can check it out from there, or you can again do let me know. I will give you the links. PPIRP portion, I will give you the links. Anything else you need, anything that I can do, I'll be very happy to help you. Just make sure this is the chance of redemption. Go and make your parents proud of you. All the very best, guys, and God bless you all. This is Harsh Kachalia signing off on behalf of Logic School of Management. Thank you.